gosh, we have a packed courtroom today. So we have individuals, we have interns from the New York City Law Department. Where are you guys at? Oh, Law Department, okay, scattered. And then we have interns from New York County Supreme Court. Where are you guys at? Oh, excellent, okay. And then we have the attorneys, right? So attorneys, please, please, please be on your best behavior so that these individuals will continue in their quest to become lawyers, okay? Please be good. So as you know, I'm going to call the calendar. Please ask for the time that you need to get out the salient points of your arguments. We have about 6.5 hours of argument time requested. So again, we've read your briefs. We are fully familiar with your arguments. People v. Martin Rivera. (525). Allen v. City of New York.
Your Honor, appellant request 7 and 3.
I'm sorry? 10 minutes? Sure. 5, 2, and 5. Matter of e-children is submitted. Benet v. One City Block.
Appellant request 5 and 2, please.
Respondent, One City Block and Taconic request 4 minutes.
I'm sorry, respondent. How much time? Okay, 5, 2, 4, and 4. People, excuse me, 57th and 6th Ground v. Carnegie House, matter of IM v. City of New York. Thank you. You represent who? I'm sorry. Who do you represent? Empress. You're requesting?
4 and 2 as well, Your Honor.
Thank you. So we have 4, 2, 4, 2, and 5. 57th and 6th Ground v. Carnegie House tenants.
Good afternoon, Your Honor. Appellant request 7 and 3.
You represent? And Carnegie House? Okay.
The respondent, Your Honor, respectfully requests
626. Justice Gesmer is recused on that matter. People v. Beltry is submitted. Santa Cruz v. 58 Jerry Street. Okay, so you guys have 10 minutes to split up. You can split it up however you want to split it up, okay? Just let me know afterwards. So 4 and 2, and then 10, you tell me how you're going to do that. Prior, discuss it among yourselves outside. Prior Cashman v. Weiner.
request 5 and 3.
Who do you represent?
Joel Wiener and all the other appellants, except for one, when it does all the entity defendants and Mr. Wiener, except for a company called ZEF.
Okay, and you're requesting?
5 and 3.
526. People v. Pierre Griffin. 626. Okay, I'll try this. Shibahakvik? How do you pronounce it?
I'm actually not sure, Your Honor.
And the respondent is not here, and the respondent, as far as I know, had not put in a brief. Did you wish to submit? Sure, 2 minutes. DeGuilo v. New York City Transit. How much time were you requesting? There's no appellant, so did you wish to submit? 2. Menden Ventures v. Equitas Corporation. No respondent. There's no respondent. What did you want? You still wish to argue against yourself?
Yes.
2 minutes. Greer v. FAM Networks, LLC.
Appellants request 4 2.
424. People v. De La Rosa.
Your Honor, I'm with the respondent for the people, and we had submitted a letter that we are essentially conceding the main point. The letter was kicked back from NICEF because my adversary also filed a letter she can speak to.
And my understanding is that the people are conceding point one, and as long as the court is willing to continue to consider point two, I feel no concern.
And we have those letters with
Why don't you submit the letters to the clerk? Okay. And then we'll submit. Okay? Thank you so very much. Rosenfeld v. BM Islam. That matter is submitted. Amsterdam 140 v. Fruitopia. That matter is submitted. First case for argument is People v. Martin Rivera. Yes, whenever you're ready.
Thank you. Good afternoon, and may it please the court. Jacqueline Shelton for Mr. Martin Rivera. Here, Mr. Rivera was arrested within seconds of the police encounter, but the basis that the police provided for that arrest did not rise to the level of probable cause. And any secondary basis of trespass, the facts were only observed after the arrest had already
So
occurred.
we have an individual who tells the police that there's someone in the area in the maintenance in a maintenance shed, right? Who is in possession of a weapon.
So the unidentified anonymous tip is not relevant to the question at hand because the people explicitly abandoned that argument below.
Well, that was the cause for the police to go to the shed, right, and to contact the individuals to contact the individuals to get permission to go into the shed, right?
Exactly, and the people relied on that just to explain why they were there, but
when
not for
they-
the basis of.
When they got to the shed, the lock appeared to be popped, broken, and maybe there was a cord now trying to secure closure of the shed?
Yes, and so this is the relevant time period here. We have a lot of answered questions. We know when the arrest
At that
occurred.
point, is there maybe a reasonable suspicion for trespass?
There may be, and
And if there may be reasonable suspicion for trespass at that point, what happens next? What level are we at in terms of DeBoer? Wouldn't we be at level 3?
I answered it that way because what we did have is immediately level 4. There's no dispute that.
Do we have level 3?
I don't think so, and that's because simply the observations that occur in those few seconds before the arrest.
If a
don't
police
rise to the level.
officer approaches a place that presumably should be secure and the lock is popped off and it's held together by a bungee cord, but there are people on the other side, why isn't that reasonable suspicion for trespass at that point?
Because the prosecution did not elicit facts to establish who actually had access to this shed.
Well, let's add also that the police observed a pipe, a crack pipe on the bench in open view. So wouldn't that add to it?
So the court below did find reasonable suspicion was established by the alleged paraphernalia, but it was hotly contested below whether it was actually observed, and also the paraphernalia in of itself is not a crime.
But again, once the police officers observe the broken lock on the shed, why would that not give them enough to at least enter the shed?
Well, they didn't elicit enough facts to support what should.
What more do
that
you
should
need?
have looked
What
like.
more do you need? They spoke to the individuals, the owner or the custodian of the shed, and they had permission to enter the shed, right? They even told the police officers, they said, we're going to come and meet you, but, if you get there before us, feel free to go in.
Yes.
The police officers arrived, again, has been stated, the lock on the shed was broken. Why, again, would they not be able to enter the shed?
I'm not saying that they couldn't enter the shed. I'm saying that there weren't enough facts to establish trespass until after. The police are very clear they arrested for the paraphernalia. And then they say, really all they say about trespass is, once we had pulled him out of the shed and arrested him, the employees that were there didn't recognize him. And so that comes after they had already explicitly said that they arrested him. And they actually say the parks officials contribute nothing to the investigation prior to them going to the park.
Why, the parks officials, the fact that the parks officials didn't recognize the defendant wasn't essential to the trespass. What was essential to the trespass was that the lock was broken and it was secured from the inside by a bungee cord, which is not what the Parks Department, which I think one could safely assume is not what the Parks Department would ordinarily do.
But we don't know that because the prosecution did not elicit it. We don't know who had access to that shed. We later learned that there were to clean the park.
So under your theory, once the police officers again arrive there, the lock is broken, etc., what should they have done?
I think that arguably, and what the court found below was, if you have reasonable suspicion, level 3. But what that didn't happen. Instead, they immediately arrest.
So what should they have done?
So they should have, they have enough to detain, but not enough to do a full-blown arrest, is what I'm saying, and that's what they did.
Is trespass an arrestable offense?
It's depending on, they didn't specify what type of trespass. It's a misdemeanor that the prosecution
Is trespass an arrestable offense?
If certain provisions of the CPL about summons issuing going first are not met, then it could be.
Is it a B misdemeanor?
I'm sorry?
Is it a B misdemeanor, trespass?
Yes.
So that would be,
Depending, there are some that are just violations as well.
but in this instance, where you're talking about the shed, would it not be a B misdemeanor at the minimum?
It's
You
not.
can think about it and,
Okay,
thank
I'll
you.
address it on.
Excellent, thank you.
Good afternoon, Your Honors, and may it please the court, Catherine Murata for the people.
So did we need further inquiry at the point in time where, again, the police arrived, the lock is broken, they had previously spoken with someone from the Parks Department?
No, the officers were not required to investigate further. Here, probable cause does not require proof beyond a reasonable doubt of every element. It only should be assessed in totality of their circumstances.
So your position is that at the time they approached the defendant, they already had probable cause?
Yes, Your Honor.
For probable cause to arrest for what?
Trespass.
How did they know that he was not there, that he did not have permission or authority to be in the shed?
Well, I believe given, all the surrounding circumstances of his presence in the shed was more probable than not that defendant was trespassing.
But there was is it correct in the timeline that your adversary indicates that there wasn't confirmation from the parks employees who were also present that he didn't have the right to be, or they didn't recognize him rather, until after he was already placed under arrest?
That's true, but to Justice Gesmer's point, I don't think the recognition or the non-recognition of the parks officials is, dispositive here. I think there was other circumstances to generate probable cause. It's 9 p.m. at night. When they enter the shed, defendant is tucking something to his waistband. There's a crack pipe right in front of him.
Was the crack pipe an arrestable offense?
The crack pipe gave the officers reasonable suspicion.
But it was not, they would not have been able to arrest him for possession, is that correct?
Correct. The crack pipe was on the table in front of him. It was not on his person, so there was not probable cause for the drug paraphernalia.
So what are we talking about here? Are we talking about the gun recovered as a search incident to a lawful arrest?
Yes, correct, Your Honor. Given that the officers had probable cause to arrest for trespass, the subsequent search of defendant was a proper search incident to arrest, and they recovered the firearm. Also, I just want to note that as an initial matter, defendant's claim is also waived. If there are no further.
And so if there's a valid waiver, then this issue in terms of the suppression would not survive that waiver, is that correct?
The suppression claim would, the defendant's valid waiver would bar review of the suppression claim.
That's what I'm saying, it wouldn't survive the waiver. if there's a valid waiver, then that would foreclose any objection to the suppression.
Correct, Your Honor. Yes. If there are no further questions, we ask that you affirm.
Thank you.
Thank you.
Did you wish to address the waiver issue at all, counsel?
Very briefly, just 3 quick points. Not a valid waiver because the court departed from the model colloquy, and in doing
wait,
so,
That's not in itself a reason to find a waiver invalid.
Correct.
If one uses the model colloquy, it protects you from getting reversed. But it doesn't mean that if you choose to do it differently, that it's necessarily reversed.
yes, and I say that under the umbrella that I think that impacted the errors in the case. The first was that the court, in the model colloquy, there was this hotly contested suppression hearing, and yet the court did not advise, as part of the colloquy, the model colloquy requires that an appeal waiver would actually cover this issue that was hotly contested below. And then second, there's also an explicit misstatement of the law where the court tells Mr. Rivera that in somewhat lumping the trial rights of what normally would happen if he had taken the case to trial, the court explicitly says that he's waiving his right to representation by counsel and for that to be paid for if he's indigent.
Well,
Was
did
there
the
a
judge also ask, follow that up with saying if the defendant, if he couldn't afford to pay for it, his attorney, that the state would provide one for him?
He says that, but then says by pleading guilty and waiving your right, you're giving up that right.
But the court also stated that the appeal waiver was separate and distinct from the rights automatically forfeited by his guilty plea. Certain rights survived the waiver, and certain rights survived the waiver as well.
Yes, but it doesn't fix the inherent misstatement of law and the failure to talk about the suppression hearing at all. I do just want to point out, we do have a little bit of body-worn camera in this case for the court to review, which I submitted as well, which does make the timeline very clear. I know that there's some back and forth about what happened when, but in the People's Exhibit 3, it does kind of lay out the specific timeline of how this happened. And because the arrest that happened was not supported by probable cause, the fruits of that unlawful arrest should be suppressed.
Thank you both. Allen v. City of New York. Yes.
May it please the court, Lindsay Smith from Legal Aid Society, counsel for plaintiff appellant Jared Allen and the proposed class. Good afternoon. This lawsuit challenges the NYPD's policy of routine and unexplained handcuffing and arraignment, which violates the due process rights of criminal defendants across New York City. Due process prohibits restraints in criminal proceedings without a prior individualized judicial finding of necessity.
Counsel, can I ask you in the first instance, how does your client have standing in this case, or is it an exception to the mootness doctrine, or how do you see that? Because that was one of the bases upon which the judge dismissed.
Yes, Mr. Allen had standing because he pled an imminent, concrete, and reasonably certain harm that provides injury in fact under Leno versus City of New York, decided by this court in 2012, PBA versus Division of New York State Police. In the declaratory judgment context, Klosterman v. Cuomo. All of these cases discuss that the standard for injunctive and declaratory relief is either ongoing or future harm. Therefore, the lower court's suggestion that Mr. Allen should have waited after he was injured to file his lawsuit, he would no longer have standing at that time because the injury would be complete. He's no longer facing an imminent injury, which again is the requirement for that injunctive relief. And Your Honor.
So the moment in time in which you're saying there was this harm was prior to him appearing before the court?
Yes, Your Honor.
As he's appearing?
He filed this lawsuit from before he entered the courtroom, before he had begun his arraignment. At that time, the NYPD still has an undisputed written policy requiring that every single person be handcuffed at their arraignment without the individualized judicial finding of necessity that best requires. And in fact, it's structured in such a way that by the time defendants can make a challenge, the harm has already been done.
Is an arraignment a criminal proceeding in the context of People v. Best and all the other case law that deals with that issue?
It is, Your Honor. While People versus Best just deals with a bench trial, the appellate courts applying Best have not waited for the Court of Appeals to apply it to each individual factual scenario. They have applied it to a wide range of different criminal proceedings that include suppression, probation revocation hearings, grand jury, even an involuntary commitment hearing for a mental health matter.
Have any cases applied this to the arraignment stage where there has not been a determination, a judicial determination as to bail or anything of that nature?
They have not, Your Honor, but if we look to Hurl Herring versus State, that case holds that arraignment is not this pro forma sort of proceeding that,
I'm sorry, that case holds that arraignment is not?
yes, Your Honor, Hurl Herring,
Statement in the dissent, I believe.
Right.
pardon me?
I believe that statement in that case was in the dissent.
Right,
No.
it wasn't in the, I didn't see that in the majority of, I haven't seen any cases that talk about arraignment in terms of a critical stage.
The page
No, Your
you
Honor,
cite
that-
to for that purpose is in the dissent.
The language about defendants' pretrial liberty interests, that's in the majority opinion in Hurl Herring.
But specifically as to arraignment, that the specific language about arraignment is in the dissent.
If I may, Your Honor, I reviewed this case last night. I don't think that is accurate, but I would be happy to take a look again at that.
So I did not see any cases which talk about arraignment as a critical stage.
Again, we're relying on Hurl Herring for that point. The case says at page...
But is there not a distinction between a parole hearing and arraignment?
Of course there is, but a probation revocation hearing, which was at issue at Hobish, is actually a post-trial proceeding. That does not bear on guilt and innocence in the same way. But arraignment, as the court says in Hurl Herring, I'm glad to look back at that case, but the language is that defendants' pretrial liberty interests are, quote, regularly adjudicated with the most serious consequences, both direct and collateral.
Pre-trial after arraignment.
Right, that, it's not a fact-finding stage yet at arraignments.
It is not a full-blown evidentiary hearing the way some of these...
It's not even a half-blown evidentiary hearing. Arraignment, the defendant is simply made aware of his or her, of the charges against he or she, and bail is set at that point in time. That's what occurs at arraignment.
Respectfully, Your Honor, I disagree. Arraignment includes a lot of fact-bound determinations. Those include...
You know how many arraignments I've done in my career? And I think most of the judges, the majority of judges on this bench, and a couple of judges who are in the audience here today, we've done arraignments. We've sat on arraignments, so we kind of know what occurs during arraignments. I don't believe that that there are any cases stating that it's a fact-finding proceeding.
Can I ask one?
I see my light is on. May I respond?
Justice Bahati, hit.
I wonder if your argument might be that because a defendant's liberty might be at stake at the arraignment because they're deciding whether or not there's going to be an ROR or some kind of bail or a supervised release now that that's going on. I'm wondering if that is maybe what pushes this into just as to maybe just a calendar appearance, but this is an actual proceeding. Something's actually happening here.
Yes, this is not a calendar call.
It is not a what?
This is not simply a calendar call. This is, as Your Honor mentioned, there is a bail determination that requires the judge to make an assessment about whether the defendant is likely to return to the court, whether they are a flight risk. Putting a person in chains before the person has to make that decision.
Okay, well, we're not talking about, you say this in your papers, and, we're not talking about chains. We're talking about handcuffs. But you do have time. I'm sorry, Justice Gesmer.
You referred to the necessity of having an individualized judicial determination before an individual could be put in handcuffs. But given that the arraignment is the first judicial appearance, I don't understand how there could be an individualized judicial determination on that issue before arraignment.
So the right and best is not the right to have handcuffs removed halfway through the proceeding. It's about the government does not have the power to restrain somebody without first having that finding.
I understand, but I thought you said that you couldn't that the defendant couldn't be put in handcuffs without an individualized judicial determination. And how could that occur before an arraignment?
It could occur exactly as it does in other cases where this right is applied at different stages. For example, the arraigning court has jurisdiction as soon as the accusatory instrument is filed. That's per CPL 2017. That is before the person is brought onto the record.
So
is that-
procedurally, how would this occur?
That's,
How would it occur? An individual is arrested. He or she is taken to the precinct. They do the pedigree information, et cetera, is taken. The individual is then taken to central booking. After central booking, the individual is then taken for arraignment. At what point in time would there be any determination, any judicial determination as to whether or not handcuffs should or should not be used?
If the NYPD found that thought that there was an individualized reason specific to the defendant that justified handcuffing that person, the NYPD could either themselves or through communication with the prosecutor approach the bench at a sidebar before the defendant is brought onto the record.
And that brings us back to now whether or not this is a criminal proceeding for which the defendant needed to be present. I mean, it seems like such a circular argument. How do we get around that?
The defendant would have to be present in order for if it's a critical proceeding, right? The defendant therefore has a right to be present. There could not be a sidebar or any ex parte communication without the defendant being present. And your argument is that when the defendant is present before the bench, he or she should not be handcuffed. So how would that determination be made?
Again, the NYPD could approach the bench. I'm not asking about something ex parte.
The defendant
I'm
would
talking
have to be present.
The
Or waive
defense
that
attorney
right.
Could be present.
Or
Excuse
waive
me?
that right?
No.
Then
Or
we'd be here,
waive.
then we'd be here on a whole bunch of other issues.
Your Honor, this is the same thing we do at hospital arraignments, for example, when the need for example, a virtual arraignment is something that is discussed between the parties before the arraignment goes onto the record and begins. This is the same thing that happens in Gonzalez, that Third Department case from 1985.
Again, I do, okay, you have time on rebuttal.
Thank you.
May it please the court, Alina Jerker on behalf of the city.
So, counsel, I'm wondering if the reason behind the handcuffs is a safety reason. Is that?
That's right.
That's what it is. And so everyone who's arrested poses this safety reason just by virtue of being arrested?
I think that, okay, so the challenge is,
I mean,
right, I want to just be clear that,
well, if everyone is going to be handcuffed, and the reason behind the handcuffs is that there's a safety reason, then everyone who is handcuffed and before the court presents a safety reason. Is that your argument?
no, I think there's a couple of things here. First of all, the policy on its face, as you can read it, actually says that there's discretion. The plaintiff's complaint states that it's a broad policy. The actual policy, if you read it, says officers have discretion and are guided to bring people in handcuffs, as we do with transportation.
But in
of anyone.
reality, how does it work?
I think that we're
I
talking.
mean, we know how arraignments go, and one after another. Where is there time to be having judicial determinations on whether they should be handcuffed in between all that going on in reality?
That's exactly right. I mean, I think that if we're talking about what is the justification behind the policy, that's not really here nor there, but the point
Well, but
is,
we also have to deal with, and we're at a motion to dismiss, and the complaint very clearly alleges that despite the fact that the policy says that the NYPD has discretion, that as a practical matter, they exercise that discretion so as to handcuff everybody.
right, and so if we say on a motion to
So
dismiss.
we have to
and-
be dealing with everything in the complaint is true at this point.
Absolutely. And so if the policy is that the police officers are bringing everybody into the courtroom in handcuffs, we're talking about an arraignment courtroom, as Your Honor said, everyone has been in one of these. We're not talking about a calm judicial proceeding. There are people coming and going. People are being brought, usually in a large group, brought to a bench or a holding area, then called and recalled to the bench at the same time. Witnesses, prosecutors, friends and family, just members of the public are coming in and out of the room. So they are held in an area and brought up when called to the podium. And at that point, the criminal court doesn't have any jurisdiction over this person yet.
How,
They haven't had their charges given to them yet.
hold on a second. If all of that is going on, how do you balance that with the fact that because there hasn't been any determination, there's a presumption of innocence, right? Why are people who are presumed innocent handcuffed when they're before a court?
So when the accused is in the custody of the NYPD, they're still there on probable cause for the basis of their arrest, right? They were arrested in the last 24 hours, and rather than trying to delay the process of arraignment by creating a new proceeding that does not exist in the CPLR and that's not constitutionally required, to first have a sidebar and decide whether or not you would
So are you
have.
stating that the presumption of innocence does not apply at that point in time?
I think there are cases that suggest that the presumption of innocence attaches after a person is arraigned, but I don't think that that is.
Do you have a case that says that?
There is a case in our brief, and there are several cases, and what they talk about is that, like at Bell versus Wolfish, the 14th Amendment proceedings, you have a substantive due process rights in your pretrial, and at arraignment, it transitions from the Fourth Amendment to the Fifth Amendment, and there's a whole set of different presumptions. But of course, they're presumed innocent.
The New York jurisprudence is very different from federal jurisprudence on this issue.
They are, of course, presumed innocent until they are proven guilty. But that does not mean that they cannot be handcuffed, because
Or there's a particularized determination as to why there should be handcuffed. But from what I'm understanding, it's the policy to handcuff everybody.
well, I think what's critical here is that that's not what the cases say. That's not what Best says. Best doesn't say that the plaintiff, that the criminal defendant has a right to never be seen in cuffs in front of the judge. In fact, what it says is that, and all of the New York case law presumes, if you have a bench trial and there is suppressed evidence, we presume the judge is able to disregard that. The judge is the one making that determination. So the error in Best was the judge continually leaving. That's what the court case says.
Best says
Articulated
that
no justification.
Best says that a defendant during a criminal proceeding, the court that restrains a defendant during a criminal proceeding must state a particularized reason for doing so on the record. I guess
Exactly.
the question is, when does the court have the opportunity to do that? By the time the person appears in front of the court, they're already in handcuffs.
Right, so
How do
what
we practically do
Best
it?
is not saying that this criminal defendant had a right for this judge to make a determination before the bench trial about having a different judge make that determination, or they would be prejudiced, right? Like how would it happen? The defendant is brought in restraints in Best, and the judge's obligation at that point was to make a determination on the record that restraints should be removed or not removed, and
as a
state it on the record.
As a practical matter, I mean, do we really need to get into all of this in terms of the policies, practices, et cetera? Isn't this just a procedural issue in terms of whether or not the complaint is sufficient and therefore should go forward?
Okay, and I think that the point is that NYPD's policy presents zero obstacle to the judge making that determination. A person is brought up for their arraignment, and the court says, I see there aren't handcuffs. I want to make a judicial determination on the record about why, if this court were to recognize that as a constitutionally recognized right, NYPD's policy presents no obstacle to that. The first opportunity that the court has to see the defendant and make that determination is the arraignment.
But this
And
was
at that point,
this was dismissed on standing and mootness grounds.
So I think that if you read the decision, it really wasn't dismissed on standing grounds, and I'm a little confused by this being so much of the argument. The decision says that because there are some questions about standing, the court is rejecting the plaintiff's request to convert to summary judgment and to address the merits and issue a judgment. And instead, the court is saying, because of those concerns, and because because the city had not charted a summary judgment course, I'm going to assume that those standing issues could be resolved by amending the complaint, and just say that on the merits, there is no constitutional right to a pre-arraignment judicial determination, and NYPD's policy presents no obstacle to the to the court recognizing and making that determination as necessary. If this court or the Court of Appeals were to say that that right exists, that right wouldn't mean that the defendant can come into the courtroom, cannot be seen in handcuffs ever in the courtroom. It would mean that when they get to the podium, the court orders them. The police would, right? If the court says, you were in an arraignment courtroom, take the handcuffs off, officer, they take the handcuffs off. The point is that until that court order, there's an indictment, until there is an arraignment and the court has jurisdiction over the criminal defendant, they go from being the accused who are arrested and held under probable cause to becoming a criminal defendant against whom charges are being brought.
Justice Geisler, you have a question?
I had a question on a slightly different approach. In your brief, you state that one of the reasons for your position is that guilt, and I quote, guilt and innocence are not determined and rarely considered at arraignment. But both everything I've ever read about arraignments and my own experience there is that a considerable percentage of the cases at arraignment are resolved by a plea, at which obviously guilt and innocence are considered. So how can you state in view of that that guilt and innocence is not a relevant factor at arraignments?
As I understand it, at arraignment, when the court is taking a plea allocution, they're not asking, did you commit the crime? The purpose of the
I
plea
beg your
allocation.
pardon.
I'm sorry, what were
Have
you
you ever
saying?
been to arraignments?
I'm sorry, no, I don't do arraignments. I'm a civil lawyer. So
Oh, well,
if you want,
yeah.
but the point is, there's a difference between, as a legal matter, what you're taking, a plea allocution and a guilty plea, or someone is taking at an arraignment. The courts, first, you know what, put all of that aside. At that point, the person is before the court, and the
I only
court
brought
can
it up
make
because
that
you argued it
determination.
in your brief, counsel. It wasn't my idea, it was in
I
your
mean,
brief.
the case law does say that the determination, there were plea agreements that were entered into where all the person said on the record was, yes, I accept the plea. And the Court of Appeals said, that's sufficient because you don't need to look into whether or not, they can't make a statement that's inconsistent.
Court of Appeals stated that, yes, I accept the plea is sufficient?
I don't,
For the person
I
that
don't
I
think
plead
so.
against charges.
I don't think so. And, you know, we have a former chief judge of the Court of Appeals. We can ask him. But, thank you. You have time. Thank you
I
very
do not.
much.
Thank you, Your Honor.
I don't think they ever said that.
and in fact, I think they said the opposite.
Yeah, I think so.
Thank you. A few more things on rebuttal here. I'll be brief. In terms of whether Hurl Herring says that arraignment is a critical
Well, I
stage.
mean, I did have a question in terms of exactly what the motion court did. Was there a dismissal? Was it dismissed on standing grounds?
Yes, on page 3 of the lower court's decision, the court said, quote, it is incumbent on the court to first consider the threshold issues. And then on page 5 of the court's decision, it says, quote, assuming arguendo, end quote, that the standing issues were resolved, they proceed to this failure to state a claim issue.
I have another question, a history question. You talk about when this policy was adopted. What happened before this policy, do you know?
So there is some information about that in our complaint. I believe there is an amicus brief filed by some other public defender offices in New York City that
There's been
points
a motion
to.
for an amicus brief by those organizations, but go ahead.
There is a motion to file an amicus by those organizations. I believe in that brief they described that in. I'm not sure if Your Honor would like me to describe that since it isn't yet part of the record, but
It is not part of the record.
Yep. But that would be where some of that history is. As far as Hurl Herring, I just want to point to Respondent's Brief, page 16 and 17, which acknowledges that according to Hurl Herring, arraignment is, quote, a critical stage of the criminal prosecution. So my colleague here, my counterpart here, seems to agree with that characterization of Hurl Herring, which again is the basis for our understanding that arraignment is that critical stage that has these serious consequences that whether they're strictly speaking fact-finding in the same way that a suppression hearing is, of course they're not at that same level, but decisions about whether a person is a risk of flight, whether a person is a danger to somebody else, which is of course the standard for an order of protection, whether the person is amenable to treatment, whether, as in Mr. Allen's case, he was offered a favorable disposition, a disorderly conduct. I see my light is on. May I finish this point?
Disorderly conduct.
Disorderly conduct at arraignment as a plea to 2 misdemeanor counts, a relatively favorable disposition. The judge had to decide, is that appropriate for the alleged conduct? These are all considerations that can be affected by the inference that handcuffs create that a person is dangerous and untrustworthy.
Thank you both.
Thank you.
Benet v. One City Block. Yes.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant. In this case, as you know, the trial court denied summary judgment to the plaintiff on 240 and 241-6, and actually granted defendant's motion, just getting rid of 241-6 totally and 200. I'd like to focus on 240, subsection 1. This is a double 240 liability case, violation case, where the duct, he was removing the duct, he was on a ladder, duct falls, he gets
Why is
knocked
he
off
on the
ladder.
ladder?
Well, because he was given a ladder. Because he
Well,
wasn't given a,
Wasn't he told to wait until he gets a scissor lift?
Your Honor, our position is that he was never given the lift, and he was never told not to use the ladder. So let me take.
But there is conflicting testimony in the record about that, isn't there?
Your Honor, I think if you look at, let's start with the instruction, the alleged instruction, which is really a standing order. So if you look at page 706 of the record, Seguenza, who's the plaintiff's foreman, actually conceded. The question is, did you have any conversations with the workers specifically about that ladder? Answer, at that moment, no. So what he did was, he had a group of workers on the 4th floor, which really wasn't the 4th, it could have been the 4th floor, but really was the 3rd. But anyway, he had a group of workers that he talked to in the beginning, and then he sent the plaintiff and Mr. Lopez to do work on the lift to remove the ducts. He admitted at 706 of the record that when he went to the 8th floor, he never instructed them not to use the ladder.
But isn't that a standing order that they work in pairs and that they use a scissor lift?
Well, a standing order under this court's law is not sufficient to establish recalcitrant worker defense, but even if that is looked to be as a standing order, what happened was, then Mr. Seguenza goes to the floor, and then once they are working for an hour or two together on the man lift, this is what happens. He tells Mr. Bonet to then come off the lift and work alone, taking down the ducts. And Mr. Bonet says he was instructed to use the ladder. He was told to use the ladder. There was no lift that was provided to him at that point. He was.
Counsel, I guess one of the things I found baffling is that your client attached to his motion for summary judgment the foreman's deposition, which said, among other things, that he had directed the plaintiff to use a lift, to wait until one was available, and forbade him from using a ladder. So it seems to me that his very motion created a triable issue of fact.
But our position is that's a standing order. It's not an instruction.
Well, that,
That's
not how I read the
Yeah,
testimony.
It's 706 of the record, and then if you look at 679 of the record, it's the same thing. So you told him to wait for the 3rd lift, or the people on the 2 lifts to finish what they were doing. I said 2 things: wait for them to finish, or I will bring you another lift. That's a standing order. He never said.
On page 706 of the record,
Yes.
it talks about the fact that he had this conversation with them when they were in a meeting on the 4th floor.
Yes.
He didn't repeat that conversation when they were up on the 8th floor.
right.
But, so is it your position that that needs to be repeated every single time they move floors?
No, but that.
Because in the cases that we have where, in these 241 cases, sub-1 cases, where the plaintiff hasn't been told, doesn't know about the alternative safety device, so we can't really attribute it to them. But in this particular instance, it seems to be a little bit different.
Our position is that you don't have to repeat the instruction on every floor, but when you do the standing order on that one particular floor in the beginning, he was just giving a safety talk. Then he told the plaintiff to remove the ducts separate from Mr. Lopez.
I think those orders were very strong. It's like never use the ladder.
He never testified that he never said, I said never to use the ladder. He said that he spoke to the group of workers, and then when he
That
didn't.
was one person. I think there were 2 people who told him this, who gave those instructions.
It was just Mr. Seguenza, and he gave the instructions, a standing order on the 4th floor, and then he told the plaintiff and Lopez to go work on a lift, which they did for 2 hours. Then Mr. Lopez goes up and then tells Mr. Bonet separately to get on, to take the ladder and to remove the ducts. And so at that point, that he would have to have been given a lift and refused to use it in order to be recalcitrant under this court's precedent. And he was never he was never given a lift. In fact, there was only one
But I
man
thought
lift.
the sequencer said, wait, now I'll bring a lift. A lift
Right.
will be brought.
But he never brought the lift. He instructed.
But he said to wait.
Can I just finish my sentence?
Please.
Sure. So he said to wait, and I will bring a lift. And no, it is undisputed on this record that no man lift was ever brought to the plaintiff to use. He was told to use a ladder. So in order to be recalcitrant under this
So wait,
case,
I'm sorry. In the record, it says that after he told him, wait, I'm going to bring a lift, someone else or that same individual foreman told him, use the ladder? That's in the record?
That's plaintiff's testimony. Plaintiff testified, I think it's at 242 of the record, that he was told to climb up the ladder to take the lift down. Yes, that's
But
what his...
Sequenza specifically stated that he told plaintiff and others not to use the ladders to remove the air ducts.
And our position to you, Your Honor, is that that is a standing order because...
Makes it a
Yeah,
standing
what makes
order?
it a standing order?
Because it makes it a standing order because then he told Mr. Bonet, after he was working with Mr. Lopez, then he told Mr. Bonet separately to separate himself from Mr. Lopez and to remove the ducts.
But isn't
using a
there
ladder.
look, I looked at all of this testimony. I thought that Mr. Sequenza also testified at the safety meeting at the beginning of the shift that the workers were supposed to use lifts if they were working at heights, and it was forbidden to use a ladder, and they were required to use a harness while working on the lift. So, I mean, there's so many different things that people testified in this record. Doesn't that create the issue of fact? And how do we get past that?
Should I take it now?
Yeah.
or
Yes.
reply? I think that the key is, with regard to a standing, I think the key is what was he told when he was then told to remove the duct with the ladder? Not what he was told in the beginning during the safety meeting on the 4th floor. When he went to the 8th floor, what was he told at that point?
So does Sequenza or anyone else state that they specifically told your client not to wait for the scissor and to use a ladder?
My client and Mr. Lopez, yes, Mr. Lopez's affidavit, in his affidavit, he said that Mr. Seguenza told plaintiff or he saw plaintiff speaking to Mr. Seguenza and then taking the ladder and using the
Yeah,
ladder.
he doesn't say that that he heard or that Sequenza ever told your client not to wait for the scissor but to use the ladder.
But-
He says he didn't hear the instructions, but he believed that that's what the foreman said.
Right, but if you, I just refer, I'll take it again.
He specifically said he couldn't hear because he was wearing
He
headphones.
was wearing earphones, but he saw him speak to him and then take the ladder. But I think 706 just shows you, did you have any conversations with the workers specifically about the ladder? At that moment, no, it's 706 of the record. He never told the workers not to use the ladder. So under Peralta, this case, the decision from this court, in order to be recalcitrant, you'd have to be given a safety device to use that was available and refused. And here, our position, there was one man lift on that floor and Mr. Lopez was using it. So he was relegated to the ladder.
Thank you. You do have time on.
Thank you.
Good afternoon. May it please the court. Patrick Lawless of Wilson Elzer for respondents One City Block and Taconic. The Supreme Court properly held that there were issues of fact whether the plaintiff was the sole proximate cause of the accident. Mr. Seguenza gave a very specific instruction to the plaintiff prior to the accident. Not only did he...
Why isn't that a general stand-in instruction? There was some time that had passed between that instruction and the plaintiff's accident?
It was a specific instruction as to the work he was to perform and how to do it. He gave him a specific instruction. Not only did he tell him to wait until a lift became available before removing the duct from the ceiling, but he said in the meantime, he was to clean up the area of debris with his coworkers. That's what the work he was going to do until one became available. This isn't a case where the plaintiff was given a task and the only way he could perform the task was he needed a ladder to do it and this was the only ladder available. He was given 2 tasks to do that day. He was specifically instructed to clean the area until a lift became available, and when one was made available to him, then, only then, to remove the duct.
But the plaintiff testified that he was told by Mr. Seguenza to use the ladder. So did Mr. Seguenza ever explicitly dispute that statement?
Mr. Seguenza said, he testified that he was specifically instructed all workers at the site that ladders were forbidden.
Did Sequenza ever specifically state, no, I never told the plaintiff to use a ladder?
No, he never specifically said no in this instance, but the only testimony he said as to the instructions he gave the plaintiff prior to the accident was he was to wait until a lift became available, and until a lift became available, he was to clean up debris
So
in
to
the
some
area.
extent, is the plaintiff's testimony that he was told to use the ladder. Is that unrebutted?
No, it's not. It is rebutted. It's rebutted by Seguenza's testimony that he was supposed to wait until a lift became available. And the plaintiff's own testimony almost supports Mr. Seguenza's version, because the plaintiff said prior to this incident, he'd never used a ladder to perform this work. He'd never seen anybody use a ladder. It was always on a lift. So
What do
that
we do
makes more
about-
sense.
What do we do about Mr. Lopez's testimony that he sees Sequenza and the plaintiff speaking, and then immediately after he sees the plaintiff use a ladder?
Well, I think this is just all issues of fact, because it's still contradicted by what Mr. Seguenza said. Mr. Seguenza said that he specifically told the plaintiff to clean the floor and then wait until a lift became available. Then he left that floor. So I think there's just issues of fact, and the court correctly found that these all created issues of fact, whether the plaintiff was the sole proximate cause.
So correct me if I'm mistaken, so there was what your friend refers to as a standing order, never to use the ladder and to use the forklift instead. And then there was another order saying, just clean up for now and wait for the scissor lift.
Correct. That was a specific instruction as to work to be performed at that time.
So there was just more than one standing order.
I would say there was a standing order never to use ladders at the job, that they were forbidden, and a specific instruction as to how the plaintiff was to perform his work at that time.
Thank you.
Thank you.
Do you want to speak to 241 sub 6?
Oh, sure. I can let my friend do it
Okay.
here, or unless,
Oh, no,
because I see my
no,
time's
go
almost
ahead.
up. Thank you.
Afternoon, Your Honors. Marina Barcia of Kahana Feld for Respondent Elite. I concur with my counsel here on the 241 and can answer any additional questions you have, but specifically on 241 sub 6 and 200, we believe that the lower court was correct in dismissing both of those causes of action, because none of the industrial code violations that were cited by the plaintiff have any bearing on how the accident happened in this case specifically, and that this is a means and methods case, not a defective condition case, and the means and methods were controlled by EDCC, plaintiff's employer. Therefore, neither Elite and I know co-defendant's position as well as that it's a means and methods case and that they did not control.
But on the 241-6, that was the cause of action that the court actually dismissed that.
Correct.
Did not find issues of fact.
Correct.
So why did they do that?
So the 3 industrial code violations that were cited as a basis for 241-6 liability are 23-1.21B1, which deals with the strength of
Right,
ladders.
the ladder could not sustain the weight.
Correct. And
It wasn't fully opened also, or could not be fully opened.
so there is no evidence that the ladder was not fully open.
And I think did he not testify or state that he had inspected it beforehand?
He had inspected it, he himself had moved it, it was sturdy and in an open position, the floor was level, nothing slipped. The ladder itself was knocked over with plaintiff by the duct. The ladder is not defective, it was not broken. There is no measurement to the ladder of how much weight it could hold. There is no measurement of what actual height the plaintiff was on the ladder. I know he testifies that he was on the 10th rung of a 12-foot ladder, but we don't actually know. Ladders have a bit of variability when it comes to height, so none of these industrial code violations are actually violated. By
So we don't even get to any of the testimony.
Correct.
Which there seems to be some conflict with to deal with the 241-6 sections.
Correct.
Thank you.
Thank you.
So I think I'd like to just try to put 3 things before the court to show what I mean about the standing order. So again, I talked to you originally about page 706, but if you...
Well, do you agree with your friend that there was also a instruction to your client that he should be cleaning up the area of debris?
Well, that was before he was told to go on the lift. Yes, the 4th floor he was cleaning, or the 4th floor he was cleaning the debris before he was told to work on the lift. That's true. But if you look at 486 of the record, this is Lopez's affidavit.
Sorry, what page?
486 of the record. Paragraph 3, the foreman Giovanni Seguenza instructed Darwin and I what to do that day. He told me to cut pipes, and he told Darwin to remove the ducts. Giovanni Seguenza told me to use a man lift, and he told Darwin to use a 12-foot A-frame ladder. There were no other man lifts or ladders available for use on the site that day. So when I referred to the standing order at 679 of the record, again, the question, the instructions that you gave about waiting for these guys to finish on the lifts, was that to everybody, to all 4 or 5 people that were supposed to be cleaning the garbage, or was that to Darwin or someone else? The whole group that was there. That is a standing order. That is not a direction. Do not use the ladder. Here's the lift. That would render Mr. Bonet recalcitrant under this court's precedent. And Mr. Lopez actually testified at 603 of the record, in the 20 to 30 minutes that Darwin was cutting the duct from a ladder, did a man lift ever arrive to that floor? Answer, no. He was never given a lift. That renders the defendant liable.
Do we know how long he waited?
I'm sorry?
Do we know how long he waited?
Well, it says 20 to 30 minutes.
But he wasn't cleaning?
No, at that point, he was on the ladder.
Okay.
Thank you all.
Thank you, Your Honor.
Matter of I am an infant. Yes.
May it please the court, Hannah St. Marie on behalf of the city appellants. This court should reverse for 2 independent reasons. First, plaintiffs cannot meet their burden of establishing a special
Counsel,
duty.
I have a question just in terms of the timeline. When the city respondents, they were on the scene first.
Yes, Your Honor.
And how long before they turned over the plaintiff to the Empress respondents?
Your Honor, the pre-hospital care report summaries from both Empress and the FDNY EMTs reflect the timeline, which is the EMTs were dispatched at 2 a.m. They arrived on the scene at 4 a.m. 2:04 a.m. They made contact with Ms. Bryant at 2:06 a.m. and then at 2:15 a.m. the paramedics assumed direction and control.
So their first contact with the plaintiff, with the mother, was at 2:06?
Yes, Your Honor.
And then Empress arrives at 2:15?
Empress arrived on the scene at 2:14 and assumed control at 2:15.
So they assumed control at 2:15. So they, FDNY had, let's say, custody from 2:04 to 2:16?
2:15, yes, Your Honor.
2:15.
The first twin was born at 2:10.
That is what the pre-hospital care report summary says, Your Honor, but both Bryant and both EMTs testified that the twin was coming out as the EMTs arrived in the apartment, which would presumably be when they are making contact with Ms. Bryant, and that birth happened almost immediately. EMT Milner testified that the baby was, twin A was coming out as they came into the room, and he reached out and caught twin A.
Was there something in the record from the experts in terms of the delivery of twins? If it doesn't occur within 10 minutes, then there should be a transfer to a hospital, or there's some alert that there's an issue?
So there's 2 different 10-minute rules that are referenced in this matter. One pertains to the choice of hospital, which is not an issue in this appeal. And then the other is the REMAC protocol states under emergency childbirth that for multiple births, if the second birth does not occur within 10 minutes, begin transport.
So what is the 10-minute time frame? What's the 10-minute time frame that's operable in this minute? Because if some of the records say 2:10 and you're telling me now that it was upon arrival, which would be 2:04, within those 10 minutes before they turned plaintiff over to Empress, what's their obligation?
Their obligation is to take care of Bryant and twin A, which means assessing the status, which at that moment was that after she gave birth to twin A, she did not need to push. She told EMT Milner that. She was not feeling contractions.
and the baby was not, a twin B was not crowning at that moment. And so when the REMAC protocols refer to attempting delivery, I mean, the first instruction that they say is to apply gentle pressure against the neonate's head, which you simply can't do if the head is not coming out because it's not crowning. So they assessed that scene. They determined that because of that, the best course of action was to take Bryant, twin A, and twin B to the hospital which, as they testified, presented the best place for care. And
Well, what about the testimony that they told her, or she was told not to push? I mean, if twin A is coming out at 2:06 when they arrive, why would there not be some assumption or suggestion that perhaps twin 2 is coming soon?
Because, may I finish?
Go ahead, please.
Because all of the indications were that twin B was not coming soon because she was not crowning. The mother said that she did not need to push. So even though she alleges that she was told not to push, she said she did not need to push at any time prior to arriving at the hospital.
Well, there was some inconsistency, right? I mean, it was inconsistent as to whether she was told to push or not told to push, right?
I don't believe there's any inconsistency as to whether she was.
I thought she stated that she was told not to push, but she wanted to push.
She said that she was told not to push, but that she wanted to get twin B out.
Yeah.
Yes, Your Honor. But again,
Well, I think the only way she's going to get it out is by pushing, right?
But was there testimony from her that she didn't feel like she needed to push?
yes, Your Honor, and that testimony was also given by EMT Milner, that he heard her say that she did not need to push, and it was documented in the pre-hospital care report summary that she did not need to push.
Thank you.
Thank you.
If Your Honors, please, Ed Guardaro for Empress. Your Honor, I can affirm the timeline. The 2:10 birth, we'll just take it at 2:10 because it's the later time. So essentially, the crew comes downstairs, and now we get into this 10-minute issue.
When you say the crew, you mean FDNY?
Well, the FDNY or the EMT crew, they come down with the stair
Right.
chair. They deliver it
With the plaintiff.
With the plaintiff
with
the plaintiff and baby A.
in the stair chair.
Yes.
They deliver those patients to Empress's people, and they hop into the back of the FDNY ambulance.
What time do they deliver them to Empress's people?
Excuse
What
me?
time does
I
Empress's
think
people?
2:15 is probably the time.
At 2:15?
Correct.
And what does FDNY do after that?
So one of the EMTs drives the FDNY ambulance, which the two patients are in the back with the two Empress paramedics, and the other EMT from the city of New York drives the other ambulance. So there's three medical personnel in the ambulance going to North Central Bronx. There's a driver.
But at that point, the FDNY medics had already made the decision that they shouldn't try to encourage the plaintiff to give birth at home instead of getting to the ambulance.
Correct,
They
Your
had
Honor.
made that decision already.
Correct, Your Honor. There was no crowning and no other indicators, and the REMAX standards specifically base everything on crowning. In fact, on 2519 of the
The
record,
words used that. I didn't think those were the words the REMAC instructions actually used. They said immediate, but didn't define.
on 2519, if you look, Your Honor, it talks about, even if there's contractions, the next step would be to assess if there's crowning. If there's no crowning, transport. That's what it's as simple as that. I mean, I would urge the court that it's as simple as that. And here we have, proof that there was no crowning from all of the medical personnel involved. And then, as a causation argument, we could argue that if you look at the NCB record, of course, there was an artificial rupture of the membranes that had to be done. There were 4 position changes. They had to do an ultrasound. Now, it all occurred in 15 minutes after arrival at MCB. That's just good medical care. But the point is, it took a lot of hospital obstetrical maneuvering and personnel to get that baby out.
How do we look at what's on page 1143 of the record, where the record indicates with imminent birth of second baby, and then further down says she doesn't feel the need to push, but it says imminent birth of the second baby. Why isn't that subjective that we might need a trial for?
Excellent question. That's exactly what the trial court thought. The trial court felt that the words being used imminent by the crew was the be-all and end-all. And I would submit to the court, if you look at the record and the REMAC protocols, the word imminent is sort of a fuzzy word, but the critical portion is, even irrespective of the testimony of the medical personnel, if the baby is not crowning, the baby's not going to be delivered. And the REMAC protocols say if it's not crowning, you got to
But
transport.
if the mother is pushing, would then the baby not start to crown?
According to this record, Your Honor, if you look at the NCB record, it took 4 attempts at pushing at NCB. They had to artificially rupture the membranes. They had to do an ultrasound just to make sure that the baby's heart rate was all right. None of these
I
things.
thought the record was that once she pushed a couple of times, then the baby popped out, according to the
Wow.
record.
So if you look at, let's see, four times is, if you look at the ultrasounds on 1651, 1648 is the pushing, 3519 is the pushing, position changes 1592, 1681 and 1546 are the baby positioning and the heartbeat checks.
There was like a 40-minute time frame. How long after she arrived at the hospital before?
15 minutes, Your Honor.
15 minutes.
There was a-
But that was 40 minutes altogether from the time.
40 minutes between, yeah.
Right, if I
Between
may,
births.
Your Honor. I just also want to point out that we started to talk about the 10-minute rule. The Empress crew and the FDNY ambulance didn't leave the curb until 2:29. If the baby was born on 2:10, that's 19 minutes. That 10-minute rule is the condition.
Well, again,
is
the
met.
issue is whether something should have been done at the scene as opposed to actually transporting to the hospital. That's
But
one
the
of
argument is 10 minutes and crowning. So, thank you, Your
you.
Honor.
May it please the court, appearing for plaintiffs, Annette Hassapidis.
So,
Court
Counsel, I have a question specific to the city defendants, and in
Yes.
terms of the timeline. It appears that if the first baby was born at 2:10, and then the Empress paramedics were on the scene at 2:15, for which that time transfer of care is handed over, given the REMAX standards, which both experts testified to at minimum was 10, I think one expert said it could be 15 minutes, what is the city's liability within that 5 minutes?
Well, the problem here is that the city told my client not to push.
But she didn't have the urge to push.
She didn't, but Satori admitted that delivery was imminent, her word. And Milner said that while he didn't think it was imminent, he knew she would deliver quickly because she had been a mother.
But everybody testified that there was no crowning. Like, there's no dispute as to that there wasn't any crowning at that point, right? They did check her.
Correct, but our obstetric expert pointed out that the fact that there isn't crowning doesn't mean that delivery isn't imminent, especially when you're telling a woman not to push, or as Empress did, not instructing her to push. There was no attempt to mate here, and our expert explained that 10 minutes isn't simply a time where everyone stands around with a stopwatch. There was an affirmative statement made to her not to push, and our expert explained that this is what delayed delivery. The fact that they had to rupture her membranes when she got to the hospital a half hour later perhaps is not a surprise, as our expert pointed out, because she had been instructed not to push and then never told to start pushing.
So that discretionary direction is your argument?
It is not discretionary, it is ministerial. I would point out that in cases where the city complies with the REMAC protocols, like Perez cited in my brief, they cite the protocols as evidence that they complied with the standard of care, right? But when they do not follow the REMAC protocols, they decide, or they argue it's discretionary, and it's our position that they can make that argument to the jury. The plaintiff didn't move for summary judgment here, they did. It's our position that a jury should decide whether those protocols were discretionary or ministerial. Our expert explained—
If the 10 minutes hadn't expired yet, right, how do we look at that? If all the experts are saying that within 10 minutes, anything can happen, there's no crowning, there's no imminent birth, she wasn't crowning, and then they transfer care over to Empress and I'm specifically talking about the city at this point,
Yes.
not Empress.
Yes.
Because that's less than a 10-minute period.
Yes, but they told her not to push. Their expert affirmation does not address the testimony of my client that she was told not to push and does not explain why that would or would not have made a difference.
But wasn't it the goal to get her to the hospital as soon as possible?
Not according to the REMAC protocols. What the defendants overlooked here is that these REMAC protocols are developed by professionals who make a decision about whether an ambulance versus a hospital, whether the time to get to the hospital is worthwhile versus a delivery in the ambulance. Ambulances are equipped, according to the protocols, to deal with complications
Well,
from
there was in
delivery.
the record stated that the ambulance was not equipped because the ambulance did not have or would not have had the monitor, et cetera, to assist with the birth.
That's correct, Your Honor, but our
Or
obstetric expert
if a
explained.
C-section, or if a C-section was necessary.
But our obstetric expert explained that the lack of an ability to monitor the fetus was all the more reason why they should have attempted delivery on site. Our obstetric expert explained that when the second twin doesn't deliver immediately, that could be a problem. And so the absence of fetal monitoring essentially means you have to assume that there could be a problem and attempt
So
delivery.
your
for 10
argument
minutes.
is that once FDNY came and, again, the first twin was being born, right?
Yes.
That at that point in time, there should have been some steps taken by FDNY to determine whether the second twin was coming.
Yeah, to start
And to start assisting in the birth of the second twin.
Correct, and I just want to make the point that counsel has said that the only time delivery is imminent and you follow the protocols as if there's crowning.
And that does not seem to be what your expert said.
That is not what our expert said. That's not what the protocol said. And counsel has even said that the term imminent is fuzzy. All the more reason for a jury to decide the issue.
Let me
Our
just ask
expert-
this one question, then. How does that take it out of the general government duty owed to all citizens and then create this special relationship? Because that's what you need here.
That's correct. And the REMAC protocols and the 10-minute requirement to attempt delivery is evidence that inaction could lead to harm, that the delay could lead to harm, which is exactly what happened here. There was a deprivation of oxygen to the baby, who now lives in a residential facility for the rest of his life. I just wanted to make one final point, even though
On rebuttal, thank you. Oh, you don't have any
I don't
rebuttal?
have
I'll give you 2 minutes. Go ahead, 2 minutes.
3 out of the 4 EMTs said delivery was imminent. The PCR said that my client had steady contractions, that there was no crowning, but she felt the urge to push. A jury should decide whether or not the collective acts of these emergency responders constituted a departure from care, created a special relationship, and caused the infant's injuries.
I just have one other question.
Yes, Judge.
The fact that they say that she didn't feel an urge to push, there's no reason for them not to say to her, try.
That's correct. And frankly, by the time she was turned over to Empress, she had the urge to push. That's what the PCR says. Thank you.
Thank you.
Just quickly, Your Honor, I want to point out that the question for the city here is not whether the city acted negligently. The question is whether plaintiffs are able to show that there was a special duty. Specifically, we're focusing on the second Cuffey factor, which is knowledge. And in Kovitz, the Court of Appeals made clear that the question is whether it's clear that the danger in the chosen option outweighs the danger in the option not chosen.
But based on the different expert opinions we have in this case, isn't that an issue of fact for a jury?
No, Your Honor, because again, the question is whether plaintiffs can show that taking her to the hospital was clearly more dangerous than attempting birth in the apartment. And we have expert testimony that shows that she was not crowning, did not need to push, and did not feel contractions. And there were significant dangers for attempting birth in the apartment, in addition to not having fetal heart monitoring.
Well, she had already given birth in the apartment to twin one.
Yes, Your Honor.
So you're stating there's significant dangers, but she had already done so with the first twin.
Merely because a significant danger had already existed doesn't mean that they weren't trying to prevent additional danger from happening. At that point, they were still in a non-sterilized environment versus a hospital that authored a sterilized environment with OBGYN care. Twin A needed the neonatal ICU. And in addition, there was no fetal heart monitoring. And just quickly on governmental function immunity, DMTs made clinical decisions here regarding the care of plaintiffs. They based it on limitations of the scene, no fetal heart monitoring, no sterilized environment, and they made the determination that she was not crowning and did not need to push. And based on that, they decided that the best thing to do for Bryant and for both twins was to bring her to the hospital. And this court has already rejected plaintiff's argument that the protocol automatically makes the decision clerical or ministerial in Morales.
Thank you.
Thank you.
Thank you, Your Honor. Just something quick about the word imminent. I said it was fuzzy because 4 different medical people were testified under pretty extreme questioning about what their definition of imminent was. It's not defined in REMAC. It's not. And so if you read the REMAC standards, it says we're going to categorize something as imminent, but irrespective of contractions or imminent, if there's no crowning, you transport. So it's not that the word imminent is fuzzy. It's not defined in REMAC.
The precise language of REMAC?
I'm sorry?
Did you just quote REMAC accurately?
2519, yes. It says that. If you look at and that's why I put it in a footnote in the brief, because if you look at it and you look at 2519, you'll see that it says check for contractions, right? And then whether it's check for crowning. If no crowning, transport. So I would submit to the court that the issue is not the word imminent, but rather the.
Is there no deviation from that? Is there no room for deviation from that? If there's a check for crowning, if there's no crowning, transport? Is that it?
That's the protocol. That's the duty. Our argument is it's a duty. We were held by the trial court to a duty to instruct the patient to push. That's the trial court found that the issue of fact for Empress was whether or not they should have instructed the plaintiff mother to push. There's nothing in REMAC protocols to instruct the patient to push.
2519 does not say that if the baby's not crowning that you transport. That's not, it doesn't say that anywhere.
I would submit to the court that.
That's not what, I mean, that was my question. That's not what it says. So I'm not
very
really
top of the
understanding
page.
your argument to that extent.
It'll say look for crowning.
If there was crowning, prepare for imminent delivery, but it doesn't say if there's no crowning, the only remedy is transport.
Transport. Thank you.
Thank you.
Mm. 57th and 6th ground, v. Carnegie. Justice Gesmer is recused. If there is a tie, another justice will be vouched in. Yes, whenever you're ready.
Good afternoon, Your Honors. Gail Pollock of Morris & Cohen on behalf of Appellant Carnegie House Tenants Corporation. First, I note that this is a 4-judge bench. In the event there is a 2.
I said that. I said in the event of a tie, the rules of the court are that another judge will be vouched in.
I would respectfully request permission to seek oral argument before the panel, including the 5th vouched judge, if there is a 2-2.
That is something that will be considered at a later date. But you can continue with your argument.
So, Your Honors, we're here so that you can determine whether a court must confirm an arbitration award even when the underlying arbitration process is compromised and lacks integrity.
I wonder how you get around the fact that there was a neutral arbitrator, well, from the respondent side, from the tenant side, that agreed and signed off to the award. Even if we were to find that maybe there was bias, how do you get around that part?
Sure. So first, our party arbitrator.
Counsel, if you could just speak into the microphone, please. Appreciate
Our party arbitrator could not cure the appearance of impropriety created by the neutral. To take a step back, what is a party arbitrator supposed to do?
But did they not have the ability to not sign off? I mean, the bottom line is that they signed off on it.
Well, they signed off on a decision, A, that preserved their objection to the evidentiary rulings.
Is that what they did?
Yeah, there is a dissent.
I thought they signed off on the total agreement.
In their affidavit, they went clarifying, maybe they're reaching the point that you're trying to make, but at the time, I don't know if that's reflected in the record.
No, I'm sorry, Your Honor. If you look at page 41 of the record, that the arbitration award begins on page 38 of the record. Page 41 are the signature blocks for the award. And in his signature block, the party arbitrator, Mr. Raber, says, "Nothing herein is intended to imply a change of my dissent from the panel's order granting landlord's motion to strike documents and to preclude related testimony dated June 27, 2025, made by arbitrators Sharon Locatel and Eli Mattioli." So in fact, the party arbitrator did preserve his dissent to the panel's decision to reverse itself after Developers Council offered a financial inducement to the neutral arbitrator, after which the neutral arbitrator changed panel determinations, allowed developer at the last minute to put in pre-hearing briefing that's...
Well, it wasn't exactly a pre-hearing briefing. It was a pre-hearing motion. I'm not sure. I mean, there are different things you could say. They did do the motion. I mean, one of my concerns was that your side complained about having to even respond to that motion because you didn't think that was part of what the rules were. And when you were told to, well, you have to respond, you were only given 2 days. Is that correct? Respond to.
That's correct, Your Honor. And to be clear, the motion court found that was very concerning. But the motion court found that it felt that it was not entitled to consider the umpire's decisions.
Because it didn't affect the merits of the whole arbitration.
No, because it's a discretionary determination and because arbitrators are given so much latitude in making determinations. When you think about the standard to vacate an arbitration award, it's so high, and that's why the process is so important, Your Honor.
So, I mean, I can see the appearance of impropriety. We as judges have to always be concerned about the appearance of impropriety. But does the standard with arbitrators require there to be ultimately a finding of prejudice, or is it, I'm not sure, I'm not positive because the cases seem to go a little bit in different ways. And I wonder if you can address that.
Absolutely, Your Honor. I think every case that specifically addresses this issue, appearance of partiality created by a financial inducement, for example, or some other type of arbitrator misconduct, every case that really looks at that finds that the prejudice is the appearance of partiality. If you look at every other case that the developer cited or that the motion court relied on, for example, the Rose v. Lowy case, it was an inference of partiality that the court found was inadequate. If you look at other cases, there are never facts, documented facts, supporting the appearance of partiality. And I think that's the real difference between this case.
But didn't the umpire cure that when he declined the offer?
No, Your Honor, and that's the thing. I know that the developer has said, well, look, we disclosed. If you look at cases like Kern, the issue is that you don't, the issues that those courts sort of hung up on is the lack of disclosure. But what's the point of the disclosures, Your Honor? The point is so that the parties know and so that the aggrieved party can make a determination.
And so then the tenants made a motion, I don't know if it's formally a motion, within the context of the arbitration proceedings to have the umpire removed. Is that correct?
The tenants did two things, Your Honor. First, three things, I guess. Since the umpire had been appointed by the AAA,
right.
First they approached the AAA, but the AAA said, "Look, this is
that's not our thing."
Then the tenants approached the umpire and said, "Look, you tried to take a job from Developers Council. you weren't robust in your disclosures, frankly. You got to recuse yourself at this point. The die is cast, and the umpire said no. At that point, the tenant went to court and said, this is unsustainable, even though courts, really, really frown upon
So you did this during that period of time, and while the arbitration hadn't started, like during the procedure.
Correct. And tenant was absolutely transparent with the umpire, said to the umpire, look, we're going to go to court, and we're going to try to have you removed, to be frank. And the umpire said, I'm going to push this arbitration through so fast that you can't get me removed.
Right, because there were certain days that had already been set aside, and then it was resolved in significantly shorter time period.
Well, and beyond that, Your Honor, that is absolutely
The
accurate.
days were longer, the lunch breaks were shorter, right?
And the panel had already set this schedule. Again, the panel had set this schedule during the pre-hearing conference at the start of the proceedings. All of this changed after the Developers Council offered the umpire another position. And you can't get behind the motivations of the umpire in making these determinations. That's what cases like Cody, which is again a case that deals.
But many of the determinations and rulings were in your favor by the umpire, right? Later on, were they not?
I don't think so. I'm sorry. Is there something specific, Your Honor?
Were there any rulings that were totally that were totally against you?
Well, yeah. I mean, they struck the heart of our case out 5 days before the arbitration began. There were no interim rulings that
They struck a lot of the expert testimony that you had been gathering for a long time. Isn't that wasn't the point that one of the major points of the motion?
Yes.
Right, and that was the basis for the motion and also the prejudice and the showing of bias, right?
Exactly, Your Honor. 5 days before the hearing, all of a sudden, a primary thrust of our case taken away.
You have time on rebuttal.
Thank you, Your Honor. Excuse me.
Good afternoon, Your Honor. Stephen Meister for the respondent. I want to start with Mr. Raber's jointer to the award. That was the party arbitrator for the tenants. As Justice Moyne said, when he joined that award, he committed himself and the tenant to a path where retreat is not possible, and he may not be heard to impeach his own award.
What do we make of his statement in signing off on the award?
Okay, that's exactly what I was about to go to, Your Honor. There's a very, very important distinction between agreeing to the final amount of value, which in this case happens to be $301,250,000, and the preservation of his dissent to the preclusion order, okay? So he agreed. This is a unanimous tripartite panel. The party arbitrator for the tenant agreed to the value of $301,250. He did not dissent to that. He did not say that he didn't agree to that value. He said, I do not mean by agreeing to $301,250 to waive my prior dissent to the preclusion order. Now, the preclusion order was...
I don't think he waived it. He doesn't even use that term. He doesn't waive his prior dissent. He kind of reinforces
That's what I'm
prior
saying.
dissent.
He preserved, yes, Your Honor, we're not disagreeing. He preserved his prior dissent to the preclusion order. Now, I want to be clear, if I may, for a moment, about the propriety of that preclusion order and what happened. The lease says that the land must be valued as if vacant and unimproved. That's not uncommon. And what happens is, of course, you have to take the highest and best use, which all of the appraisers, not the party arbitrators, the expert appraisers who testified at the 5-day hearing, agreed was to build condominiums in this location, 57th and 6th. What happened was that the tenant's lawyer sent a 23-page instruction letter to his arbitrator to say, I want you to alternatively value it as if you can't have condominiums and only a co-op. We didn't know, the landlord had no knowledge that there were going to be two appraisals, one at $165 million, which was based on condominiums, and one at 112 million, which was based on the co-op use, until the day that those appraisal reports were submitted, which was a few days before the hearing. The landlord's arbitration counsel moved to preclude the lower appraisal report, arguing that the instruction letter from the tenant directed the appraiser to violate the standard of determining the value in the lease. That was granted by two of the three arbitrators, the umpire and the party arbitrator for the landlord, Ms. Locatel, and it was dissented to by Mr. Raber. But Mr. Raber agreed to a value of $301,250 and said by his own testimony in his affidavit that he agreed to that value in order to get the value down. In other words, his testimony—
He was afraid it would be even higher if he wasn't, if he hadn't been on the
Exactly,
panel.
Justice Kapnick.
That
And
all that doesn't go to the bias. And
it goes to the finality of the award, which in my view, and I'll get to the bias in a minute, Your Honor.
Well, I mean, I think my colleague and this bench would probably appreciate you get into the bias now, because if there's so much bias, does that, and because he agrees to the finality of the award, but there's so much alleged bias, let's say that.
Right, then the bottom line is that what other choice did he have at that point in time?
All right, let me try to unpack this. First of all, going to a question Justice Kapnick raised about this split of authority before the U.S. electronics decision, I would commend the Justice's attention to the statute to begin with. 7511 says, when an application to vacate or modify award may be made, and then it says, if the court finds that the rights of the party seeking the vacatur were prejudiced by 1, corruption, fraud, or misconduct, 2, partiality of the arbitrator appointed as a neutral. So it's very clear.
Does that mean that the prejudice is the partiality?
No. It does not.
Say that.
It means that there has to be prejudice in excess of the partiality. That's exactly the syntactical structure of the statute. And let me point out, it is not correct to say that prior to the Court of Appeals 2011 decision in U.S. electronics, that the rule was that if there was an appearance of partiality, there had to be vacatur. There are 9 or 10 decisions of appellate courts. I think 6 of them came from the Appellate Division First Department, all of which track the statutory language I just mentioned that require actual outcome determinative prejudice. There were 2 minority decisions, 2 out of 11 or 12, that talked about an appearance standard.
Can I just interrupt 1 second? What could arbitrator Raber have done? Could he have dissented in full?
He could have refused to sign the award. I'm glad you asked that. That is a question I'd love to answer. He could have and should have, if his client wanted to bring this proceeding, dissented and said, I don't agree, suffered the higher value, whether that would have been 330, 340, or 350 million. By the way, my client's appraisal was 350 million, I believe, okay? So it would have been something north of 301, 250 and south of 350 million. He should have dissented, refused to sign it, and brought this. When he didn't do that, he created finality. This is not a vacatur standard case. It is a finality case. If you look at the case we cite, matter of...
Can I ask you one other question, or maybe 2 other questions? So I know that the tenants did submit an expert affidavit, since we have all our former colleagues involved here. We have an expert affidavit, but there was no expert affidavit that you submitted on this whole concept, and I...
Okay, I'm glad you also raised that, Justice Kapnick. That was obviously Justice Acosta's affirmation. That affirmation strictly spoke to recusal. It never mentioned vacatur, and it never mentioned Raber's execution of the award. Okay? So what the Acosta affirmation says is that, in His Honor's opinion, there was an appearance of impropriety created which should have required recusal. There isn't a case in the history of New York that says that if a neutral creates an appearance of propriety and should, based on that appearance, grant a motion to recuse, and then doesn't grant that motion, and the award is fully rendered, that vacatur occurs because of the declination of the recusal motion. There's no case.
See, the other thing is, it's not like the arbitrators are going to issue a decision and they're going to say, we really don't like you, and that's why we're making this decision. Here's prejudice, exhibit 1. I mean, it's not ever that obvious. Certain things we have to read between the lines. So as soon as this whole motion to have him recused and all that went down, all of a sudden, not only did the 2 of the 3 arbitrators strike all that expert information, but they also reduced the amount of days of the hearing.
No,
And they
that's not right,
They
Judge.
added longer days, and they made a very,
That did
very
not-
tight hearing.
That did
Hold
not
on, that's
occur?
not right.
That did not happen?
That's not right, respectfully. There was a 5-day trial hearing set long before the recusal issue. It never changed. It took a long time. The arbitration was very delayed.
But it was a longer, I thought.
No, it was not, Your Honor. It was not. I promise you, it was not. There were 2, what do they call, alternative days that were kind of scheduled, but it was scheduled as a 5-day hearing before any of this happened, okay?
What about the striking of the,
Because, Your Honor, we didn't, there's no evidence, including Justice Moyne's opinion, there's no evidence that that was the product of bias. There's,
well, I mean, that's the whole issue. That's the whole question. There's no, can you draw that inference? I mean,
Yes,
why can
you
you not
can.
draw that inference based upon actions which occurred afterwards?
because you look at the lease, Your Honor, and the lease says that the land is valued free and clear and vacant as of the valuation date, which is a little before the renewal of the lease.
If it's so clear, then why did you have to do a pre-hearing motion when it was already decided by umpire Maltioli that it was not necessary?
Because, and I wasn't the lead counsel or even the counsel on the arbitration hearing, but I spoke to him at the time, because he didn't want to consume 2 days or 1 day questioning an expert witness on an appraisal report that was legally impermissible in this context. He made a legitimate in limine preclusion motion and said, this appraisal report, first of all, you got 2 reports from the same appraiser for the same date for the same property. It's a very unusual circumstance. And why didn't he do that? Why didn't he do 1 report with 2 values? The answer is he knew the preclusion motion was coming, and he knew it was going to get precluded because the $112 million appraisal was not legally correct and it violated the lease. So he did 2 reports so that when the first report, the lower report, was precluded, he had a report to go to trial.
None of this is in the record. This is just your speculation as to
No,
what
this
occurred.
is not my.
I mean, it's not in the record, but thank you.
Thank you, Your Honor.
Okay, Your Honors, I'm going to try to tick through a few things really quickly, although I'm obviously happy for your questions. First, you just heard a whole lot of argument about this pre-hearing brief or motion or whatever it was and whether it was appropriate and whether there were 2 sides to it. You did have a dissent from the panel's determination. That's the whole problem here. You can't get behind the motivation of the 2 arbitrators, and particularly the umpire, in determining what he was thinking in allowing this motion to be filed 9 days before the hearing, and in granting the motion just a few days before the hearing. You can't get behind it. There's not going to be a smoking gun of bias. I think the fact that the panel changed its earlier determination and allowed
pre-hearing submissions, I mean, I'm not sure how much more ham-handed it can be, Your Honors.
I think the issue is, at least for me, is that it's a very heavy burden that you have to carry. And I mean, that's what the cases say. So I'm not, so how have you met that burden?
I mean, we have showed that without telling the tenants' council, developers' council reached out and communicated directly with the umpire, offered the umpire a job during the pendency.
But is that in and of itself sufficient?
Well, I do think that it is, Your Honor. Actually, the courts are very clear. We want to talk about precedent here. Look at Catalyst, Cody, Uniformed Firefighters, Fisher, Grendy, and Kern, which say you have to be particularly concerned about financial inducements or economic concerns. And
I mean, you talk about Catalyst. Catalyst says that you have to show that there was some type of increased financial benefit to the umpire.
Catalyst also says, Your Honor, it is only necessary to demonstrate the potential for bias to find misconduct. Kern says the same thing. The appearance of impropriety or partiality is sufficient to warrant vacator of the award. It is only necessary to demonstrate the potential for bias to find misconduct.
So I just want to ask you to go back to another issue I've been struggling with. So does there have to be something more? Look, the Judge Moyne found that there was some appearance of impropriety, put that on the first page of his opinion. It was a lengthy opinion, but he didn't find that. Nonetheless, he found that you didn't make the burden that you needed to make. So does there have to be some more tangible prejudice other than all the things that happened that sort of lead to an appearance but don't lead to a tangible showing of prejudice? That's the place I'm a little having a hard time with.
No, Your Honor, you don't. And I think that cases like Kern and Catalyst say very clearly the appearance is the prejudice. And I do want to specifically address the sort of additional burden factor that Judge Moyne found was required. It's not, Judge Moyne said, look, if you follow Kern and you follow Catalyst, I got to vacate.
Right.
I'm concerned here. I think that the U.S. Electronics case is a compelling case, right? But there's no reason that he should have found that. The U.S. Electronics case has nothing to do with this case. It is under the FAA. Your Honor, you decided a decision in 2013. I don't remember it, but it was an FAA case where you cited U.S. Electronics. The U.S. Electronics has nothing to do with the CPLR. In fact, U.S. Electronics cited Morelight, which is a federal case dealing with the FAA, which made clear actual bias, even under the FAA, you can't prove it. It's too difficult. It creates an insurmountable burden. And other cases that we've cited in our brief, Sierra, make clear that the FAA, even without its actual prejudice burden, even that it's much higher than the CPLR. So Judge Moyne misconstrued the import of U.S. Electronics. He should not have relied on it in this case. It has nothing to do. And then he went above and beyond U.S. Electronics and said, okay, U.S. Electronics FAA sets this burden. CPLR must be higher than the FAA. It's exactly the opposite. It's supposed to be lower. I do have.
You are out of time, but thank you very much. Thank you all. Santa Cruz v. 58 Jerry Street.
Reports for next week.
Good afternoon, Lisa Gokulsing for Great Maintenance. My issue is pretty simple. The workers'
I'm sorry,
comp-
can you?
We couldn't hear you.
Oh,
I'm
sorry.
Could you start all over again and speak into the mic, please?
Lisa Gokulsing for Great Maintenance. I think that my issue is pretty straightforward. The Workers' Compensation Board determined that my client, Great Maintenance, was the plaintiff's employer. On 58 Geary brought them in as a third-party defendant, but admitted that there's no contract, there's no indemnity agreement between 58 and my client. And the plaintiff argued, well, we moved for summary judgment arguing that there was no grave injury here. We demonstrated through 3 IMEs that the plaintiff did not sustain a grave injury. The plaintiff opposed by merely putting in a few reports from Dr. Golzad, none of which used the magic language that the plaintiff was unemployable in any capacity. So the lower court was correct in determining that the plaintiff did not sustain a grave injury. I'm not really clear on why the court found an issue of fact other than the fact that Capital Concrete claims to be the plaintiff's special employer, but that should not have precluded summary judgment for Great Maintenance. Thank you.
Thank you. So we're going to do 2 minutes each. Just tell me who you represent. And
My name is Ian Ash from Greenberg and Stein. I represent the plaintiff in this action.
go.
Well, I mean, our position is that our client presented credible evidence corroborated by a witness that he was struck by a falling shoring jack. And our position is that the defendants failed to present admissible and credible evidence to oppose it. You have a double hearsay report from the insurance and from the defense investigator. I don't think I have to really seriously argue that's not admissible.
I want to ask you about the hospital records.
Sure.
And because interestingly enough, in this case, the physician's assistant actually appeared and spoke about how the way the accident occurred would be germane to the treatment. Do you want to address that point?
Sure. Our position is that it's not germane to treatment, but more importantly,
But why doesn't it at least raise a question of fact?
Well, number one, Ms. Espinoza, the physician's assistant, could not, she had no recollection when she testified of speaking to the plaintiff, which I understand. She admitted that the attending doctor may have changed, she couldn't rule out the attending doctor changed the note. She could not rule out that the history did not come from the plaintiff. And more importantly, if you look at the report, this description of the accident on page 3 replicates the description of the accident on page 12 attributable to another employee entirely.
Right, but that would go to maybe the weight that it's given at trial as opposed to whether or not it's sufficient to raise an issue of fact.
You have to be able to demonstrate at minimum that the plaintiff is the source of this information. And there are extremely serious issues as to whether or not the plaintiff was the source of this information. It can't be demonstrated. I mean, the thing about the note on page 12, and it's a number that's not really well defined, it has the number 1410. Now let's assume that's military time, 210. Ms. Espinoza's note, has the time of 2:42. That would be about half an hour before. But more importantly, the hospital report makes a reference to something that's nowhere else in the record, a pulley. It's completely foreign to any other testimony in this case. It brings the reliability of the report or description into question, that brings the translation into question. But let's assume what happened here was that they're just confusing the term pulley with form. His testimony was that he cut his hand on the form when the shoring jack hit him. It's not really inconsistent. But, if everything else was fine, if there was no, if you at least had a credible translation of what the guy allegedly said, and both Mr. Ortiz, the witness who went with him to the hospital, and the plaintiff said that, they were having trouble getting someone who spoke Spanish for them. You have this accident description that's completely, foreign to any other description of this accident. There's not a single source in the record of this case, and it's extensive.
Can I ask you a different question? What evidence did you submit in this record as to the grave injury, which counsel just brought
Yeah,
up?
I would concede there's no grave injury in this case. I'm not going to waste
Thank you.
time with that. And then
Your 2 minutes is up.
Okay, very good.
May it please the court, honorable justices. My name is Magdalene Skunzos. I have the defendants, respondents, appellants.
What are their names? I
I
mean,
have-
that's very nice, but what's the name of your client?
I have 58 Jerry Street, 22 Bartlett,
So you're the owners,
I'm the
Owners.
owner.
that group.
Okay.
I have pretty much everyone except the third-party
Okay, so you have
defendants.
the owners, thank you.
So I asked this court to affirm the decision almost entirely, except for the portion of the decision that did not grant my client summary judgment on the labor law 200 and common law negligence claims. This is a means and methods case. There's two versions of this accident. Plaintiff would like to submit and cite to the progeny of case law that talks about falling objects and shoring jacks. But any way you slice it, any way you look at it, there are two versions of how this accident happened. One version absolutely does not fall within the ambit of Labor Law 240. The original version, the version contained within the employer's incident report, which is Ufredo Patino, is that the plaintiff was using a hammer, was pulling a pin, and mashed his hand with a hammer. That is not a 240 case. That does not fall within the ambit of 240. Now, plaintiff would like to submit that there was an eyewitness to the accident. There was no such eyewitness. Plaintiff himself testified that there was no witness.
Wait, I thought you were talking about 200 here.
Sorry, I jumped, did I? I'm sorry, Judge.
Right, because I did have a question about, you're saying it's a means and methods case. Is there any view that there's a dangerous condition, there should have been some inspection, the pin falling out?
Well, Judge, we submit obviously that it's not a premises case because that's why I jumped into those two versions, so sorry about jumping. Both of those versions are how the work was done, right? So the first one with the pin is stripping forms, which goes to the concrete work the Capital Concrete was performing. The second version is the shoring jack was also used to support the decking. So we submit that's a means and methods case under either version of this accident. I know my time is up. Is there any questions I can answer while I'm before the court?
No, thank you.
Thank you. Thanks.
Good afternoon. May it please the court. Anthony Ranieri on behalf of Dunco Safety, LLC. Your Honor, at the crux of this issue lies the dumb proposal agreement, which was entered into by and between the general contractor, BT General Builders, and Dunco Safety, LLC. We're requesting...
Put in opposition or motion or cross motion?
No, Your Honor, we do concede that a cross motion was not filed. However, it is our...
We're talking about in Supreme Court, right?
Yes, Your Honor. However, it is our position that CPLR 3212 subsection B does grant this court vast authority to enter judgment in favor of any party, even a non-moving party, and does
By
grant this...
searching the record, is that what you're asking?
Yes, Your Honor, that is.
Why should we do that? We don't do that all the time. Is there something special about your case that makes it appropriate to do that?
Well, Your Honor, in this particular circumstance, we don't believe that these claims shock or prejudice the opposing party. So we do believe that although one of our claims was unpled at the trial court level, it does not shock or prejudice the opposing party because Mr. Fuchs, the general contractor's representative, was questioned at length regarding the dumb proposal agreement, which did include the paragraph 5, the no delegation of duty clause, as well as paragraph 6, the no third-party beneficiary clause. So it is our position that the fourth third-party complaint should be dismissed because the only claims that are asserted against Dunco Safety are those for common law indemnification and contribution. Now, we did not owe Capital Concrete a duty of care, nor plaintiff, because again, the dumb proposal agreement does speak for itself in that Dunn acted in an advisory capacity. Dunn simply was responsible for noting any potential hazards that were on this particular job site and directing it to the attention of the general contractor. But we did not assume any sort of duty on behalf of the general contractor to maintain a safe work site. And I do notice that my time is up, so I will.
Thank you.
Thank you.
May it please the court, Brendan Fitzpatrick, counsel for the respondent appellant, Capital Concrete. Your Honor,
who are you?
Capital Concrete.
Thank you.
Second, third-party defendant.
Yeah, I don't care about that. I just need the name. Thank you.
The concrete people.
Yes, the concrete company. Your Honor, the one issue I'd like to address is the issue of the indemnification claims against my client. There's no debate that Capital Concrete did procure insurance as required by its subcontract. It procured primary
The
insurance.
excess too that you're supposed
It
to
implied,
get?
yes. I believe it was Arch, Axis, and Endurance. We procured insurance. Two of those have accepted the tenders of defense in this case. One, the Endurance, it followed form, which essentially means that you have to wait until these other policies are exhausted before we even step up. And in this case, Your Honor, we're talking about a lacerated finger. I don't believe it's going to get to the $7 million range on this case. But that's what we
Talk
have
to
here.
the workers' comp.
The workers'
comp.
We argued that we were plaintiff's special employer. Mr., I believe it was the supervisor who wrote the report that said the incident happened by plaintiff smashing his finger with the hammer.
Wasn't he also supervised by G manufacturer?
General maintenance.
G maintenance.
I do believe that he called Mr. Patino the supervisor. He's the one that instructed all the work. He's the one that had the right to hire and fire him. I believe under Thompson against Grumman, we would qualify as a special employer under the law that would support the dismissal not only of the common law indemnity, which would also actually be dismissed under North Star Reinsurance, but also under Thompson v. Grumman, because there was no grave injury here. That would also support the dismissal of any contribution claim, common law contribution claim against my clients. Unless there are any further questions, I would adopt defendants' arguments with respect to the issue of Labor Law 240, and would ask the court to reverse and dismiss all claims against Capital Concrete.
Thank you.
Thank you, Your Honor.
Yes.
First of all, the testimony of Mr. Ortiz, which I quoted directly in my reply brief, unequivocally established that he was 12 feet away, he heard the sound of something falling, he immediately walked over to where the plaintiff was, saw the plaintiff on the ground, saw the shoring post that had toppled over on the ground next to him, saw the portion of the ceiling that it had been
He
supported.
saw a post that was on the ground. He didn't know that it had toppled. He didn't know how it got there, right?
Well, I mean, if you hear the sound of something falling, you walk over and there's an 11-foot shoring post lying on the ground next to the prone plaintiff, there is you are to make a logical inference or logical deduction about what happened. And then you look at the ceiling where it's supporting the deck and now it's sagging, and it clearly doesn't support the contention that he hit a pin on the drop head came down, the thing is still erect. I mean, what we clearly have here is direct testimony. Oh, thanks. That it had fallen. And as far as the incident report of Mr. Patino, I mean, I go into the what we argue the infirmities at length in my reply in my brief. He doesn't ever attribute the alleged description of the incident to the plaintiff. The very first time he ever attributes the accident description to the plaintiff is when he appears at a deposition 3 years later. He admits that he was not on site. He admits that he got a phone call about 20 minutes later. He doesn't recall exactly when he got there. He doesn't recall exactly what later that afternoon when he spoke to him. He had complete ignorance of even most rudimentary details, what floor the accident took place on, what assignment the plaintiff had, what he admitted he could not corroborate anything about this accident. And, they're basically saying that here I have a case where we have a witness who testified, who corroborated by and large what happened here, whether or not directly precipient witness or someone who saw it immediately after the fact. And their testimony is, their position is that this accident report, which has all the hallmarks of just a self-exculpatory report, post hoc report, is enough to raise the question of fact. That just opens the floodgates in these type of cases. I would also point out one more thing. All right, very good.
Your Honors, 2 points. Edgardo Ortiz at page 2245, lines 9 to 21 specifically says he did not see how the plaintiff's accident happened. So plaintiff's counsel can stand before you and say they have an eyewitness. That's simply untrue. It's a misrepresentation. There's so much I can say. Is there any specific point that Your Honors would like me to address that has not been addressed? I know this was very thoroughly briefed. I shouldn't say, well, that's for you to decide. I'm sorry. I meant it was thoroughly briefed. So is there anything Your Honors would like me to address?
I don't think there are any additional questions. Thank you.
Thank you very much for your time.
Friar Cashman v. Joe Weiner.
May it please the court, Ira Glauber from Dilworth Paxton, counsel for defendant appellants Joel Wiener and the entity defendants. The individual defendant never should have been named as a party to this lawsuit, and the lower court never should have kept the individual defendant in this case. That's what this appeal
He
is
had an
all about.
ongoing relationship with Prior Cashman for decades, right?
Your Honor, the entities, yeah, the answer is yes.
And he told Prior Cashman to bill them at the address where Wiener Realtor was located, correct?
Your Honor, in order to hold an individual,
Is that correct?
the complaint alleges it, and we all know that the allegations of the complaint must be deemed to be true. However, Your Honor, there was no retainer agreement.
I understand that, but at the time this relationship began, it wasn't required.
Well, no, but first of all, there are 14 of these entities that were not even in existence until after the enactment of that statute. But put that statute aside, 22 NYCR. Okay. But you need a retainer agreement. You need invoices addressed to the defendant. You need legal services to be performed to the defendant.
There were invoices sent to the company, Wiener Realty.
Realtors.
Yes, Your Honor.
But where does it state specifically that you need the retainer agreement, you need the invoices, et cetera, where the complaint alleges that these conversations in this relationship was in place?
Because, Your Honor, in order to hold an individual personally responsible, there must be clear and explicit evidence of intent or clear and
So you're right, but what about all those times? I mean, the relationship was obviously with Mr. Wiener. These are all his entities. He's the person, so that you have to talk to a person. So he had the relationship with Prior Cashman, and they had conversations, and they had emails, and they talked about, can you do this for me as a favor? Yeah, we'll pay you, we'll take care of it. I mean, that was where the relationship is. And he shouldn't be, at least at this point, a defendant in this case.
It's a 30-11.
I'm sorry,
This is a 30-11.
Yeah, yes, Your Honor, but just look at each of the individual causes of action. Claim one, breach of contract.
My colleague just kind of outlined all the causes of action.
Claim one.
The allegations.
Claim one, breach of contract. There is no contract. There is no retainer agreement. Claim two, account stated.
How can you have an? Can be oral.
Pardon me?
A contract can be oral.
Certainly, Your Honor, but there has to be some evidence that the individual himself did something.
The complaint alleges that he personally requested plaintiff perform legal work for him, including a favor. There are multiple occasions where legal work was performed for the LLC over 25 years. Also, the complaint states, again, that we stated, I think this is now the fourth time, that he was billed at Wiener Realtors for legal services.
There never was a single payment made by Mr. Joel Wiener to this law firm in 25 years. There never was a single, that's correct, that's undisputed. There never was a single invoice issued to Mr. Joel Wiener. Most importantly, there was no legal services that was provided to him personally or individually. Your Honor, there are 60 different corporate entities, LLCs, that are defendants here. Those are proper defendants to this lawsuit, not the individual who is the managing member of that lawsuit without something that he did, Your Honor, that is clear and unequivocal that he made himself personally responsible. Judge Kaplan simply saying, I'll pay. Obviously, he was talking on behalf of the entity.
Well, the complaint also alleges that your client made personal assurances to pay the plaintiff and to pay plaintiff both orally and in writing.
Your Honor, on a motion to dismiss, we all know what the standard is.
Yes,
but yet, Your Honor, they had to come forth with something to substantiate, to meet their standard.
Not at this
burden.
point.
They didn't do it.
All they have to do is write a complaint.
The allegation.
Paragraph 8 says Mr. Wiener personally assured Prior Cashman by phone, in person, and via email that defendants would pay for the services rendered.
That is, Your Honor, there was no reasonable expectation because he never...
That's the allegation in the complaint. Thank you. You do have time on rebuttal.
Thank
you. May it please the court, Brian Maida from Prior Cashman on behalf of the plaintiff respondent, Prior Cashman.
I think the theme of the court's questioning is the critical point here, which is this is a motion to dismiss pursuant to CPLR 3211A7. Prior Cashman's afforded every possible favorable inference. Its allegations are accepted as true, and if the court sticks to that standard, it'll reach the same conclusion as the Supreme Court, that Prior Cashman pleaded claims for breach of contract, accounts dated, and quasi-contract quantum merit against all of the defendants, including Mr. Weiner in his individual capacity. And I'll start with the individual liability, since that appears to be the crux of the appeal. This is not about holding him liable based on his corporate status as a member of an LLC. This is about his own conduct that Prior Cashman alleges. It's what he said and it's what he did. So the
But would there have to have been no, let me rephrase that. What, besides his words, what work was done on his behalf individually as opposed to the corporate defendants?
I'll just caveat with that that's a little outside of the record, but I can say work has historically been done on his personal behalf. The services that are at issue in this case, the services that weren't paid for, are not those services, but in the 25-plus year relationship, services were performed on Mr. Weiner's personal behalf, and that.
So if everything that relates to this is for the corporate entities, how do you get to Weiner himself?
So there's two ways, Your Honor. First off, it's what he said. So at paragraph 8 of the complaint, we reference personal assurances from Mr. Weiner that were in person, over email, and over the telephone. Paragraph 93 of the complaint gets a little more specific. Here, when Mr. Weiner was facing critical deadlines with the Attorney General's office, he emailed Prior Cashman and said, please complete this work, quote, we of course pay. Then shortly thereafter, paragraph 94 of the complaint alleges that he telephoned Mr. Kremnitzer and said, please do this work as a favor to me, I promise to pay. And those are, we allege, personal promises that Mr. Weiner is going to pay for this work. That's the first theory. The second of them is about his conduct with relation to Weiner Realtors. Over the course of the
everybody knew that there was no entity called Weiner Realtors, right?
Well,
it wasn't a legal entity.
It's a non-existent entity. Mr. Weiner certainly knew that and directed all bills to that.
You certainly knew that too, right?
Prior Cashman understood that Weiner Realtors was Mr. Weiner. Mr. Weiner stood behind Weiner Realtors, and for 25 plus years, he directed all bills to Weiner Realtors, and they got paid by whichever entity Mr. Weiner directed pay the invoices. And we didn't really have insight into you know what the logical the methodology was there.
As long as they paid your legal fees, you were okay.
Until a certain point, Your Honor. So we were never in all our 25 plus year history directed to look to these individual entities for payment. And then when a fee dispute arises, all of a sudden this Weiner Realtors entity gets recanted, and now we're being instructed to go after each of the individual entities. And that's precisely what the non-existent entity doctrine is designed to avoid. Moving on to the breach of contract claim, I know opposing counsel mentioned the letter of engagement rule. For three reasons that argument fails here. First and foremost, we plead the existence of written and oral agreements. Second, the complaint plainly alleges that the relationship dates back.
There was no retainer agreement.
Well, Your Honor, we plead that there were written agreements. Discovery is undergoing, but we do plead that they exist. But critically, we also plead that the relationship dates back to 1999, 3 years before the rule came into effect, and the law is very clear that it was not intended to be punitive and retroactively invalidate pre-existing relationships. So even an oral agreement would suffice here. And then third, the rule has two exceptions that we submit. At least there are factual questions as to whether those were met and should pass a motion to dismiss. As for the account stated, I do want to make just a critical point here, which is opposing counsel in the brief mentioned these supposed objections to invoices about overbilling. I just want to be as clear as possible. We did not assert an account stated claim based on those invoices, so those objections are irrelevant. And then the only other objections that counsel asserts that they'd made are simply not specific enough, and there's questions as to the timeliness of those. Thank you, Your Honor.
Thank you. I'm sorry, go ahead.
So you don't claim that your complaint alleges that there was a retainer agreement? I just did a search.
No, we do, yes, Your Honor. It's paragraph 66 of the complaint. We allege that there were written and oral agreements governing the relationship.
A retainer agreement, per se, in those words.
What was that again?
A retainer agreement described as such. You don't ever use the phrase retainer agreement.
No, but we reference written agreement.
That's what I was asking.
Okay, thank you.
Thank you.
Your Honor, there's something fundamentally wrong with this complaint. Where is the cause of action for Quantum Merowit? It's not here, because they knew that they could not establish that. There were 4 elements of Quantum Merowit.
Plaintiff can make the choice, and their choice, their primary choice seems to be breach of contract. They don't have to allege every possible
I get
cause
it,
of
but
action, nor do we want to, nor is it our practice to infer why a plaintiff chose the causes of action that they chose.
Of course, Your Honor, but we all know that lawyers sue for quantum merit, and the law actually says if you cannot sue for breach of contract because of the letter of engagement rule, your remedy is for quantum merit. They could not meet the elements of quantum merit, so they tried to get in the back door with it. Well, but Your Honor, if they have no cause of action for breach, this is only against Mr. Weiner. By the way, every lawyer in this room wants to see payment, no doubt. We do too. But they're going to get paid because there are 60 viable entities that they did work for. They know who they are. There was no mystery who they were performing the legal services for.
Well, it does.
They sued them.
Actually, I'm not sure that that's accurate. Of course, you haven't put in your answer, and these are just allegations. But honestly, he said he got all these. They sent out invoices to Weiner Realtors, and they got paid by whatever LLC Mr. Weiner told them to pay. So I'm not really sure that they know exactly who they are, what work they do, what they did for who, and if they're able to pay them. I mean, I know you haven't put in an answer yet, and we haven't gotten
It wasn't it was the fact who they represented. They knew who they did the work for. That's why they named these 60 entities. It wasn't because they got checks from 60 of them. That's because that's the entities that they worked for.
But didn't Mr. Weiner instruct them to just bill Weiner Realtor?
Your Honor, for 25 years, they billed Weiner Realtors, which was a trade name. For 25 years, they did work for all of these various LLCs.
And I guess they used to get paid too, but
Your Honor, there was a genuine dispute. This was not just a deadbeat. There was a legitimate, genuine dispute,
Thank you.
as
Thank you all.
happens.
Thank you both. People v. Griffin. Yes.
Good afternoon, Your Honors. Nick Justice for the Legal Aid Society on behalf of Mr. Griffin. I'd like to start with the court's denial of a separate incident instruction and then move to the preclusion of the Brady disclosure. The trial court violated Mr. Griffin's right to a fair trial when it refused to instruct the jury that they could not consider a criminal propensity and that they could not infer from the mere number of criminal incidents charged that he was guilty of one or more of those incidents. The instruction is required whenever 2 separate incidents are joined in the same trial and was especially critical here because Mr. Griffin was charged with 2 highly inflammatory allegations of sexual assault.
Well, he had to be charged with the incident as to Otero, right? Because that was the only way you were going to establish the elements of predatory sexual misconduct, right? Predatory sexual assault, right?
But that does not impact the court's failure to instruct that each of those incidents needed to be considered separately.
I thought the court did instruct that.
No, absolutely not. The court made some comments to that effect in voir dire, but the court was explicitly persuaded by the prosecution before the charge conference that the instruction did not apply because of what Your Honor had just mentioned, that these were separate, that they were characterized as separate elements, or they were separate elements of a single offense. So the court came to the conclusion that the instruction was not applicable and then refused to give it on that basis.
Well, apparently, the court instructed the court instructed the jury that the prosecution must prove that he committed 2 separate crimes. They must first prove that he committed the crime of rape in the first degree against Otero, and then prove that he committed the crime of criminal sexual act in the first degree on Paulino. The court stated that they had to prove each crime separately. Counsel then asked for a separate charge, and the court stated, I think it's clear that these are intertwined especially for the other counts.
Exactly. No, the court stated that it was clear that they were intertwined. In other words, the court was not persuaded that these offenses could be considered
But
separately.
that's not the issue. The issue, as my colleague pointed out, is that the court did, in fact, when speaking to the jury, offer the charge.
No, and to be specific, the charge is just not a blanket statement that the charges should be kept separately. The charge specifies that you cannot infer a criminal propensity on the part of the defendant, and you cannot infer merely from the number of charged crimes that the defendant is guilty of one or more of those crimes. The substance of that instruction was never conveyed to the jury, and the reason it was not conveyed to the jury is because the judge became persuaded by the prosecution that it was not applicable, that the mere fact that these were elements of a single statutory offense meant that, in fact, the jury could consider that, and went back on its previous opinion. The court had at one point believed that when it denying the defendant's motion for severance, and there were comments to that effect during.
It could not have been severed. Again, you had to have, you needed in order to prove the predatory sexual assault, you had to have both incidents. You had to have Otero and Paulino.
So what I'm focusing on now, though, is the deprivation of the instruction. So that does not implicate severance. We make the additional point that severance was required as a matter of due process, in which case the prosecution would have had to first prove the charges against.
But how would the prosecution been able to have proved predatory sexual assault if the court had severed out the incident as to Otero?
They would have to first prove the charges against the first complainant and then charge predatory sexual assault under subdivision 3 on the second trial, which is that is exactly.
So you need two trials.
In this case, you would need two trials. But I do want to highlight that the issue of whether or not the jury was supposed to be instructed appropriately is a much lower standard than whether or not severance was required as a matter of due process.
Well, I'm looking at the court's charge, and the court specifically stated that they had to view each charge separately, and that the people had to prove each charge beyond a reasonable doubt.
But that charge does not convey that the jury could not use criminal propensity against Mr. Griffin or infer that he had a criminal propensity.
Was there not a general Molyneux? Was there not a general charge given by the court in terms of propensity?
No.
There was not a general charge?
No.
Okay, I'm going to take a look at the charges again. Thank you.
Good afternoon.
So, counsel, as part of the general charge, is that not given to the jury?
Well, the judge denied any Molyneux application here precisely because there was no Molyneux issue,
Right.
because there was no prior bad act. These were two acts that were both being charged in front of the jury and were both part of a single criminal charge. So Molyneux simply didn't apply. Your Honor is absolutely correct that during the body of the jury instruction, Judge Pickles walked the jurors through the fact that the jurors would have to consider each crime separately and then come to a conclusion about his guilt with respect to the overall charge.
And also, I think, if I recall, she also stated that proof of guilt as to one does not mean proof of guilt as to the other.
She did, and to be clear, Judge, not only did she say that, both parties said it. It was said at voir dire. It was said again at the end of trial as well. So they were told that they needed to consider both charges separately. As far as we're aware, they did consider both charges separately. There was, I think it's worth noting, no one ever made anything approaching a propensity argument here.
Yeah.
Counsel points to the people's summation to note how the people told the jurors that they were free to consider the facts as explained by the first victim as potentially corroborative of the story told by the second victim. That's not a propensity argument. There was no suggestion that Mr. Griffin is a sexual predator by propensity and that therefore the jury should just assume that he did.
Apparently what counsel asked for was an instruction as to separate incidents, but nothing as to propensity. Right?
Yes, and again, propensity wouldn't have applied because no one suggested anything approaching propensity. These were not two separate incidents in a particular legal sense that they were included together in a single criminal charge. With respect to the idea on the severance argument that this could have been done as two trials, It couldn't have been done as two trials, not only for the practical difficulties involved, but for more obvious reasons. Counsel cites to 13095 sub 3, the third subdivision of predatory sexual assault. If you read that statute, it's a classic bump up where the defendant needs to have been convicted of a qualifying offense at the time they committed the new offense.
Right,
And
and
of
this is
course
not-
couldn't have happened here because the first
this is
offense
not a
happened.
bump up.
Right, it couldn't have worked that way. You couldn't have simply secured the conviction on the first instance and then tried him on the second instance because that conviction did not precede the conduct.
And it was an element of the crime.
Yes, exactly. It would have to be the case that at the time the crime was committed, he had already been previously convicted of a qualifying offense. That was not the case here, nor could it have been the case because the events were separated by 3 days. So 13095 sub 3 was not an option. And in effect, defendant's argument is that he should be immune from prosecution under predatory sexual assault, under the predatory sexual assault statute. And he finds no support for that in any case law of this court, the Court of Appeals, or elsewhere. I don't know if your honors want me to cover any of the other issues raised in defendant's briefing.
Well, there's an issue in terms of Paulino's recanting of what occurred and the letter.
Yeah. Under Court of Appeals precedent, under Piazza and Devereaux, the only thing that counsel was entitled to, or that the defendant was entitled to, was to pursue a searching cross-examination of the prior inconsistent statement. He got that in
But
very substantial
the actual letter, the actual document was not introduced into evidence.
It was not. It was read directly by counsel, and he asked the victim, "Did you write this statement?" And she said, "Yes, I did." And he read. Now,
there were portions she didn't remember, right?
There was a portion she didn't remember. I think the truth is, Your Honor, if you read pages, I think it's 137 through 139 of the trial record, it's pretty unmistakable, I think, for everyone in the courtroom that she was conceding every part of the written statement. When counsel asks her, follows up after having her read it, and then says, "And isn't that your written statement?" She goes on to explain the part of the statement that she had just been cross-examined on at some length, and she clearly thought was what counsel was driving at, which was that not the "he only hit me," but the part after it, which was "no sexual contact occurred." So she does go on to spend time explaining away a part that counsel doesn't dispute, but I think there's no question that if you read the record, it is plain that the jury understood that she had written "he only hit me and no sexual contact occurred." He was able to cross on that at
The
great.
defense also argues that the people, by presenting this testimony, this evidence, was impeaching their own witness.
Yeah. So as the second and third departments have both held, this is not an example of impeaching your own witness. This is a permissible, longstanding trial tactic that's been around for at least 100 years in New York State and has always been permitted, of taking the sting out of facts that your opponent is likely to bring out on cross-examination. That happens all the time in trial practice in New York court. It is almost never a problem. In fact, as far as I'm aware, it's never a problem. The only cases that defendant points to as violations of this 6035 provision are cases where the people use that impeachment to smuggle in evidence that otherwise was not going to come before the jury. The one case they cite to where there was actually a reversal for a 6035 violation, which is Pole Hill out of the second department, in that case, the jury heard, because of this improper impeachment, about the defendant potentially threatening the witness and threatening the witness's children, information that the jury surely would never have heard otherwise, and that prompted the court to reverse. And I'll point out something worse happened in Pole Hill, and it comes from the quote in defendant's reply brief. The people also went on in that case to bolster the witness by introducing a prior consistent statement that contradicted her inconsistent statement. That was another problem in Pole Hill that warranted reversal. None of that happened here. This was a simple effort to take the sting out of prior impeachment, out of upcoming impeachment. The second and third departments have held this doesn't implicate 6035 at all. To the extent your honors are disinclined to follow the second, third departments, I would encourage you to follow your own rulings in, I think it's Urena and in, I'm forgetting, Cartagena, both of which say that these types of alleged violations of 6035 are harmless unless, as I mentioned before, the people use it to smuggle in information that the jury otherwise wouldn't have heard.
Thank
Again,
you.
that didn't happen here. Thank you.
I just want to quickly touch on the contention that this was not used for propensity purposes. I want to add that after the court denied the separate incidents instruction, it then overruled every one of defense counsel's objection during closing argument in which the prosecutor—
Counsel, I just had the opportunity to go through the jury charge and just read where and from, I think it's like record 548 to 550, somewhere around that, where the court goes through the charge for predatory sexual assault. And he does there indicate there are two separate charges and, well, two separate crimes. You have to find this and then you have to find that. Says it a couple of times, actually. So I'm just wondering how that affects your argument, because it is here in the record.
Well, but the court, when it made those instructions, did not instruct the jury that they could not infer a criminal propensity on the part of Mr. Griffin, and that it could not infer just from the fact that he was charged twice that they could find guilt based on that. That is specifically what the separate incidents instruction mandates. It talks specifically about prohibiting a criminal propensity and not simply saying that you were charged twice here.
So in every predatory sexual assault case where that's a charge, that propensity charge needs to be given? Is that what you're saying?
I would think so. There may be cases in which the two incidents really are factually related for reasons other than propensity, and then a different instruction would be required. But here, there was no argument that the incidents were relevant to each other for a
Well, there was, because I think the knife, or wasn't there something about the knife that was used as to Otero was the same knife that was used as to Paulino?
No, there was a knife. A knife was only used in the incident with respect to the first.
Brown knife. A brown knife recovered after the second incident was the same brown knife that was testified to as stated by the complainant as to the first incident.
The brown knife was not used in the second incident. It was just on his person.
I didn't say that. I'm sorry if I said that. I was mistaken.
But
brown knife recovered after second incident.
But that wasn't relevant to any of the identity was not at issue here.
It was you just made a statement that there was nothing to correlate or tie the two incidents. I was just saying that the brown knife was one could be seen as connecting the two. The other thing is that you talk about propensity. There was never any mention, the word propensity was never used by the court or anyone else.
I disagree with that, Your Honor, and I'll just quote directly from the prosecution's argument, the objection to which was overruled. This is where the defendant asserted his arrogance, his violence, and his predatory nature against these two vulnerable women.
I didn't hear propensity.
Well, the prosecution didn't use the word propensity, but that is a propensity argument. He used his predatory nature to commit.
He's charged with predatory sexual assault.
Well, that's
you have to use predatory if that's the charge.
No, that may be the name of the charge, but you cannot say a defendant has a predatory nature. That is classic propensity argument, and it went on further, using the similarities of the offenses.
I think we have your briefs, and we'll take another look at them. Thank you so much. Thank you both. Tabarovich? Did you learn how to say it during the break?
I apologize, Your Honor, I did not.
I don't.
I will be brief. Good afternoon. May it please the court, Karen Wolf for the appellant, City of New York. This court should reverse the lower court's denial of summary judgment to the city. The city made a prima facie showing that it lacked prior written notice of the defect that plaintiff alleges caused her fall. Plaintiff cannot rebut that showing, and because her own testimony and photographs, which she marked, established the defect she described is not the one that is described in the inspection report, which is all that she relies on for prior written notice. Plaintiff, as the court noted earlier, plaintiff failed to oppose this appeal. Unless the court has further questions, the city will rest on its brief.
Thank you.
Thank you, Your Honors.
DeGuilio v. Transit. Yes.
Good afternoon. May it please the court. My name is Patrick Caruana, and I represent the New York City Transit Authority. And we're seeking to affirm the lower court's order that struck certain portions of a second amended bill of particulars that alleged failure to place guardrails and alleged failure to monitor and coordinate train schedules with elevator usage. And we're also seeking to reverse that part of the lower court order that did not strike a certain portion of the second amended bill of
And you
particulars.
said that those were new claims that were in the second bill of particulars?
Correct. They were new. They weren't.
Like a
either
new theory?
New theories of liability that weren't set forth in the notice of claim. They weren't expressly set forth, and they weren't reasonably implied from the notice of claim. And really, the one of the main points is that this is a second amended bill of particulars. CPL 3042 only allows one. And there was no motion for permission to serve a second amended bill of particulars. And
So this had to do with the signage and the warnings and the failure to highlight the I-beam columns? That's the allegation or claim that you would like stricken from the
yes,
second
yes,
amendment?
yes, and the other ones they were stricken, and I'd like them to remain stricken.
Thank you.
Thank you.
Menden v. Equitas. Yes.
Good afternoon, Your Honors. May it please the Court, Taylor Lancer of Kleinberg Kaplan, Wolf & Cohen, for Plaintiff Appellant Menden Ventures FinTech Fund 1 LP. Here, the Supreme Court found that the defendant knowingly and deliberately asserted a false defense for the purpose of delaying the resolution of this litigation.
Move closer to the mic.
Sorry, yes. But declined to award sanctions only because of perceived headwinds against sanctions from this court. That reasoning constitutes an abuse of discretion and is contrary to precedent from this court. In Ray versus Ray, this court found it was an abuse of discretion for the Supreme Court to deny an award of sanctions, despite also finding that the plaintiff's conduct was entirely frivolous. The frivolous conduct there involved engaging in meritless litigation against the defendant and submitting false sworn statements.
So the defendants did not put in any brief in opposition to this motion, did they?
That's correct, Your Honor. And I would...
Thank you.
Thank you.
Last case for argument, Greer v. FAM Network, LLC. Yes.
Hi, good afternoon. May it please the court. My name is Jesse Strauss. I represent the defendant appellants FAM and Zohar. We're here on a 3211 A1 and A7 motion to dismiss. The defendants made the motion. Justice Reed below dismissed.
Yes, we're familiar with the facts.
Okay, yeah. The point being that if you look at 3211A1, you can see here that the documentary evidence that's been presented and it was attached to the complaint clearly refutes all the allegations. There are two breaches that are attempted to be alleged. Both of them are clearly refuted by the documentary evidence. The first is that there were certain accounts that my client did not have the authority to post on. There are a list of accounts. If you look at the statement of work on the first page, which is 58, they're listed as your accounts. Those are the
Were
only...
they approved by Dr. Greer?
Your accounts are the accounts that Mr. Greer preserved, the right to approve the content that was on those accounts. The two accounts that he alleges had unapproved content are not on that list. The two accounts are the Best of Dr. Stephen Greer and Zohar UFO channel, I believe is the name. Both of those accounts were created by my clients, and specifically under this agreement, they have permission to post the content on there without approval. And the reason why we do that is because if you understand the way this industry works and what my clients do here is they create new channels for existing content creators. So Dr. Greer has his content on his channels, which he has the approval rights over, and he negotiated that. My clients then take that content and put it on other channels to broaden his exposure to get him additional followers and additional revenue. The second allegation is that there was no payment to Dr. Greer. The issue with that allegation is that under this agreement, it's quite explicit that it is net income. He does not receive gross income. He receives a net.
He didn't receive a dime.
He didn't, but he might not have been entitled to a dime. And the way it's pled is it doesn't
So
pled
you've
any
been
prerequisites.
operating at a loss this whole time?
If during the course of this, if nothing was paid, then there was no net income to be paid.
But then weren't you supposed to submit a monthly invoice?
Certainly that's in the contract. There is a notice and breach provision where they have to notice that there was a breach. If you look at the notice that was sent, it only is in regards to these account issues. So the content, it says nothing about net income. It says nothing about anything else in there. Had he have gone through the right process, perhaps we would appropriately be in front of this court. The way this plea reads, all it says is he was not paid. There is no guarantee of payment in this. This is a net, and he does not allege that there was any net income.
How does your documentary evidence utterly refute that he was not entitled to any income?
The reality is that he never went through the process to get the information he did. There's an audit right in here. Had he had followed the process, which is an audit right.
So you didn't utterly refute that he wasn't entitled to any income?
We utterly refute the fact that he wasn't paid a dime because he wasn't entitled to a dime. There was nothing, this is not, it's both documentary evidence, and the other one is A7, which says he actually has to plead based on all of the elements of his claim. The elements of the breach of contract claim is not that he wasn't paid, it's that he's entitled to be paid. And he never said he was entitled to be paid. He certainly says he wasn't paid, but he was not entitled to be paid because this is net income. Once you convert, and if this court chooses to do that, once you convert a net into something where there's a guarantee of payment, anybody is going to come before this court and say, I wasn't paid. The reality is that they have to make the pleading at this stage. They have to say, I was entitled to be paid. That allegation is missing.
You have time on rebuttal.
May it please the court, Michael Stager on behalf of plaintiff appellant Stephen Greer. I think your honors were going in the right direction with the questioning there. Justice Reed was.
Well, he stated that he didn't have he didn't show, he had a right to be paid, but he didn't show that he was paid or should have been paid?
Your Honor, the specific language in the contract, which is in paragraph 33 of the complaint, during the term, you shall receive 60% profit share on your approved accounts. FAM will pay you within 30 days following the end of the month in which such income was received by FAM.
But apparently FAM did not receive any monies.
Well, we don't know that, Your Honor. That's one of the reasons we're in court.
I mean, this was a very short-lived relationship. I mean, it was like a month. I mean, it fell apart after a month.
The relationship was a month. The defendants have continued to maintain control over both their own accounts with Dr. Greer's content and Dr. Greer's channels as well. They
But
continue
their position is that he wasn't entitled to anything from their channels.
Now, their position in the case has been he's not entitled to a dime, which we allege that
Because
he was
there's
not paid.
nothing there.
I'm sorry, Your Honor.
Because there's no dime.
Well, we don't know that, Your Honor. That's why we brought a suit.
But then I thought that their position was that under the contract, under the agreement, you were supposed to make some type of inquiry or ask for an audit or something of that nature.
Well, that's one of their arguments, in addition to the contract refuting the terms of the contract. And we demanded an accounting in the case. Justice Reed was very clear in his decision that the solution to whether money or not is owed is in the hands of the defendants. And the defendants have not come forth, did not come forth with any documentary evidence in connection with this motion. They have not come forth with any evidence during discovery.
Has any statements been sent to Dr. Greer?
No statements have been sent, Your Honor.
So your friend said that he didn't have any rights to what they put on their platform, but didn't Dr. Greer retain approval rights?
Dr. Greer did retain approval rights. The contract itself is not clear on what content belongs on which platform. There are holes in that contract. But the allegations in the complaint are that they posted content without approval that violated the guidelines that Dr. Greer set out that are in the statement of work. And this, the argument on appeal was there was one video mentioned. The statement in paragraph 5 is, among other things, here are some violations, and there are references in the complaint to multiple videos. not specific videos in there. I would like to correct one thing, Your Honor, that was incorrect in both sides' papers. The site for Centrifugal Associates v. Highland Metals is 193 A 3rd 385, and that goes to right to appeal, leave to amend on a motion to dismiss. If you're,
Thank you.
thank you.
Your Honor, briefly on this issue of the profit share, the problem with this complaint is that it definitely says he wasn't paid. It doesn't say he was entitled to be paid, and that's something you need to plead. This case has been ongoing for a year now, over a year. There have been 2 experienced counsels on the case. They have never once made a motion to amend the complaint to assert that there was any money actually owed. The reason why is because there is no money actually owed. They can't make the allegations.
They set out the breach of a contract and agreement, alleged that they performed, that there was a breach, and that there is money owed. They don't know how much money is owed because the accounting aspect of it is with you. That's what they're saying. This is on a motion to dismiss.
I understand, Your Honor. If you read the complaint, though, it does not say that there was money owed. It very explicitly says he was not paid a dime. Never anywhere in this complaint does it say that there's money owed. He could go back, he could amend the complaint. They haven't amended the complaint. Furthermore, there is a process by which he was supposed to, may I continue? There was a process by which he was supposed to audit. There was also a process by which he was supposed to mediate. There was also a process by which he was supposed to do a demand. He did none of that, right? None of that. Instead, he came right to court.
Thank you.
Thank you, Your Honor.